extremely urgent matter of the determination of Justice Kaushik Chandra relating to, my lord, electricity.
Yes.
Here, my lord, I have been, my lord, I am a small enterprise under the SME Act. I have been making payment of my bills in time. Suddenly, my lord, I have got a demand on the 2nd of July that they have perhaps made some wrong adjustment in connection with some exemption that they had given earlier, and they want to recover it from me at one go, my lord, within the 11th of this month, 1 crore 96 lakhs. My lord, I'll be completely out of business. My lord, I also have decisions of this of the Honorable Supreme Court to show that charges akin to this, the bar of limitation would apply, and they would not be able to recover 10 years at a time like this.
When is the deadline for
The
making
day
the
after
payment?
tomorrow, my lord. I have come up at the earliest convenience for 2nd of July, my lord. Thereafter, I made a representation, went to them. They are not entertaining me.
2nd of July, you got the notice.
2nd of July, I got the bill. Thereafter, my lord, I made a representation. I went to them. They are not entertaining me. And they are threatening me, lord, disconnection or day after tomorrow.
They're threatening, they have given a notice for disconnection or?
But they have said that, Lord, in the bill, that if you do not pay, we are going to disconnect. Now, whether under the earlier Act, Section 24, they are going to give or not is completely up to them, because now they have integrated this in the notice.
No, but they must be giving a notice before the disconnection.
Ordinarily, they do, but here, my lord, because they are making a claim for such a long period at one time, they would, my lord, try to, my lord, coercively try and take action so that I am undone and non-suited, my lord.
Remember the
Friday.
distribution scheme of this.
Friday.
With your lordships, kindly.
Your lordship, kindly may be permitted to mention, my lord, through virtual mode, my lord.
Yeah, only if I can see you, you're upside down.
But 1165, my lord, this matter has some urgency. The
Give your-
municipality, my lord, has himself found unauthorized construction.
Give
Directed demolition, no steps there.
Give the slip. Sorry? Give your slip. Give your slip. Yes.
With regard to 1306 of the monthly list, Miller, there is some urgency.
Give your slip. Indicate the name of the councils.
My lord, may I be permitted to mention one matter for non-prosecution, my lord? My lord, my matter
us
last
slip.
appeared, my lord, what I'm saying, my lord, last appeared in the monthly list of the June, my lord.
Yes.
July, it was not appearing. The matter was moved before the
Give your slip for non-prosecution.
only thing that can the matter be fixed today, because I have a
Today?
matter today, because
Not today.
because court number 3 have passed an order. Court number 6 have passed an order for withdrawal, because I cannot proceed. I have preferred a revisional application. This matter is
Not-
standing on its way, my lord.
Not today.
Today the matter has been fixed at 3 p.m., my lord.
Not today. Not possible.
My lord, that I'm handing over the slip, because the order I am also attaching it. It's mentioned that until the matter may be withdrawn, I cannot proceed.
Very
Today
good.
matter was fixed,
How many times have you mentioned it?
my lord.
Is the first mentioning?
This is the first time I'm mentioning, because subject yesterday the matter was moved
Very good.
when his lordship asked
Very good.
that
Give
today's
the
matter
slip.
will. My lord.
My lord, may I hide myself from the video because there is some technical, I think there is some technical irrelevance in my system, my lord, for that.
Yes, tell me. Give your slip.
My lord, my lord, actually, due to my physical problem, I can't able to appear before your lordship, my lord. I'm praying apology for that. Yesterday, I've just gone to the cardiologist, and he has asked me to stay for 7 days in the home. If my lord kindly permit me to.
Hand over your slip, sir. Mr. Majumdar. Do you have a
My
junior?
lord. My lord, then tomorrow,
Yes.
with your lordship's kind leave, my lord. Grateful, my lord.
Give your slip, sir. Yes, tell me.
Your lordship, from the original side, my matter is pending for the last 1 year.
Very good.
Opposite side has violated 4 court orders. Even the one
Give your slip, sir. Give your slip. We'll see.
there with Justice Bakshi. And your lordship, I can show you evidence also. And the KMC in the written statement, they have confirmed illegal construction.
Give your slip.
Your lordship, can I be tomorrow? It's Thursday.
Why are you mentioning it like this? Give a slip.
Your Lordship, I need to make a mention on a special officer.
Original side.
Converting my
Original side tomorrow, not today.
Your lordship,
Tomorrow. Original side is not today. Yes.
I am the petitioner, my lordship. My car parking space has been converted to outsiders as restaurant by the special officer who had no office to hold.
Give me a slip.
Lord, one
If you can consider, because every time on the original side it is 100, every time I come here, it doesn't happen.
Sir, you gave your slip. We'll see that on the original side. We'll see that.
Lord, one group 5 matter, my lord.
Sorry?
One group 5 municipality matter, my lord. 5th floor is now being constructed, my lord.
Give
The
me a slip.
petition, but it has been mentioned twice, my lord.
That's
It's
okay.
not appearing, my lord.
Any unauthorized construction, it will be demolished when the time comes.
My lord, the
Yes.
petition is being threatened, my lord. It's a
Sir,
5-story building, my lord. They are
It's all right. There are many 5-story, 7-story, 10-story
but the
buildings.
developer is contending that they will construct a 7th floor, my lord.
Let them construct. Good for
Densely
you.
populated area, my lord.
Very good. Let them spend some more money. Anything which is illegal will be demolished. All right? In due course. Call out the list.
Malad, I am appearing for item number 1, Malad. It has come in my instance, Malad. Malad, on 25th, this matter was, on 25th of June, Malad, this matter was taken up, Malad. I tried to appear through virtual, Malad, but I could not get into, Malad. Malad, my name has not been recorded, Malad. I'm appearing for the
If you
state,
have
Malad.
not appeared and you could not get into, then why should there be any correction, sir? Why should there be any correction?
Malad, the
I
chat
am
has
not
not
here
opened,
to solve
Malad. I
your
could,
technical glitch. Sorry, Mr. Gupta.
Malad,
We are not here to solve your technical glitch.
Malad.
Learned counsel for the petitioner states that he could not appear due to some technical glitch on his part. He
Malad,
prays
state,
for
Malad,
his name
state,
to be
state, for the state,
incorporated.
Malad, not petitioner, Malad.
You are for
State, Malad.
state.
State, Malad, state.
And don't mention like this.
Malad, Malad.
Mr. Nikhil Gupta, who appears for the state, prays that his name has not been mentioned in the order dated 25/6/2025 due to the fact that he could not attend the hearing because of some technical glitch at his end. Full stop. This court deprecates this kind of mentioning where the respondent state has not appeared but wants his name to be incorporated to raise bills. Full stop. You don't appear in the matter and then you mention the matter.
Malad, it is not in my instance,
Mr.
Malad, the
Gupta,
technical glitches, Malad.
technical
Malad,
glitches at your end.
Malad,
Come to the court.
Malad,
Appear physically.
Malad, Malad,
Don't make these kind of excuses.
Malad.
Technical glitch. What is stopping you from appearing in the court?
Malad, due to
Why you're not coming
waterlogging,
personally?
Malad. Malad.
You should be depaneled. Likho, this today also.
Malad, 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 kindly,
The
Malad.
counsel for the state
I tender
appears
apology, Malad.
through online
Malad,
to
Malad,
state
due,
that he was not able to appear before
Malad, due
this
to
court
waterlogging,
due to
Malad,
the
I could
technical
not come,
glitch.
Malad.
Due to
Malad.
technical glitch at his end. This kind of submissions are deeply disturbing for this court. The counsel for the state,
Malad,
first of all,
Malad, I
doesn't wish,
tender apology,
doesn't
Malad.
appear in the
Malad,
court,
Malad, I
and
tender,
then
I
gets the
generally
matter
appear
listed
physically, Malad.
after
Malad, kindly,
mentioning
Malad. Malad,
the
Malad,
conduct
kindly,
of the
Malad. I
counsel for
tender
the state
apology, Malad. Malad, I
requires
tender apology, Malad.
his
Malad, kindly, Malad. Malad, at least give me a chance,
depanelment
Malad. Malad, Malad,
subject
Malad,
to
kindly, Malad. Malad, Malad,
Mr.
Malad.
Gupta.
Malad, one last chance, Malad. I'll never, Malad, do this type of act, Malad. Kindly, Malad. Malad, I tender apology, Malad. I tender apology, Malad.
How dare you mention the matter?
Malad, I tender apology, Malad. I tender apology, Malad. From next time, it will not happen, Malad.
Just to raise bills, you'll mention the matter. Next.
Deeply obliged, my lord. Actually, my lord, Mr. Vishwajit Mukherjee,
Yes.
advocate appearing for the corporation,
Early in the morning.
is
My lord, I appear for the applicant, lordship.
physically not well, mother.
All right.
Mr. Vishwajit Mukherjee.
My lord, may I make a submission, lordship? I believe if the petitioner's consent is received, lordship, my purpose should be served because it's an application for intervention.
Yes.
My
sir.
lord, may I?
Yes. Yes.
Yeah.
Sir.
My lord, I am for the petitioner.
Yes.
This was challenging, my lord, certain actions of the corporation by which they tried to enforce a demand under a UAA system without having heard me. The honorable judge taking up the matter, my lord, found, my lord, upon hearing the parties, substance in my submissions and granted an interim order and fixed the matter for final hearing. Affidavits on my side are complete. In the meantime, my lord, Big Basket is in occupation of a portion of the premises in question. It has certain perishable goods. They have applied for intervention here, pro interests who are basically, so that they could be allowed to remove those perishables, subject to what orders my lord would pass. That is perhaps his application.
Lordship, and it's under padlock at present. So if only for the
Corporation
limited
has affixed a padlock. I have also challenged their authority to affix a padlock in connection with
Yes.
assessment matters.
Mr. The application which they have filed is lying with Mr. Mukherjee. That is the main problem. my lord.
No.
If your lordship kindly fix
Right.
it on
then
Monday,
great any day, lordship.
Monday, then
Monday.
Lordship, as my lord pleases. Well, the only thing is because of the nature of the goods.
I understand his position, my lord. I
Let's have
understand
it on
position.
Friday then.
Yes, my lord.
Friday. Friday.
Friday, my lord, Mr. Mukherjee, I don't know.
That these are perishable goods, so perhaps my lord,
Monday, my lord,
can be
kindly
taken out,
here your Monday.
taken out, sold, and then the money is reserved. That can also.
This padlock has been put 2 or 3 months ago, my lord. Kindly,
No,
2 months
that's
ago.
not correct, lordship. That's not.
When has the
27th May.
27th of May.
May,
May. So
padlock
there are-
was given.
My lord, there are a lot of
4
goods.
days will not,
My lord, there are
will not make anything.
No
there
problem.
are,
No.
then we'll come back on Monday, but there are several goods perishable which will lie for 3 months or so.
would have perished by now.
If
The
Mukherjee does not
As-
come, I will do it, my friend.
Grateful,
no.
grateful, lord. I will not object to this.
In the
On
meantime,
Monday.
I should collect the application
Yes.
so that I can,
Monday.
I am grateful to your lordship.
কবে যেন expire করছে?
Grateful, lord.
Not today, Monday.
এই আমার স্লিপটা দিয়ে
If the padlock was put maybe 1 or 2 days,
Yes, then that.
then I would have.
A month is a month. But we apologize on behalf of our brother at the bar. He shouldn't have done what he is doing. This
They
can't
mentioned
happen.
these matters.
How can they come and say that I have not appeared but give my name because there's a technical
Different
glitch?
glitch.
There are certain things
And
which are,
today also he's not appearing here.
and to say that he's also appearing virtually.
And this is,
We apologize, my lord, on behalf of the bar. My lord, kindly do not take.
and we understand young lawyers, but then they should not indulge in this kind of practice. This is wrong practice.
Deviling in the chambers have gone. That is the problem.
It's really sad. Really sad.
We apologize, my lord.
I was telling Mr. Banerjee the same.
First thing in the morning, on a otherwise rainy and pleasant morning.
Pleasant morning, you don't want to hear this. And I'm most indulgent in these things.
My lord has always.
Putting somebody's name, let him raise bill,
Everyone, yeah, but then there are certain methods.
Not
There's a
this.
certain decorum. You can't not appear online and then appear online to rectify your not appearing online. Oh, bless you, bless you. We again will tender our
No,
apologies.
thank you. Yes.
Petition.
For the petitioner, item number 4.
And I appear for the respondent number 6 in item number 3.
The complainant.
Boranagar municipality is appearing online. This is that 18 and 18/1. Hatim Munshi
Well,
Lane.
last occasion, we have filed a report. Lordship directed us to make an inspection of the premises concerned. We made a inspection in presence of the parties. We filed a report. But the private parties were supposed to take out exception. I do not know whether.
The report is with us.
Report, you have the report?
Yes.
It was handed over to your lordship.
Yes. On the last occasion, I filed the report before Lordship's court.
This is the report, right?
Another copy. Now, please see the report.
Inspector side 7.
The 2 writ petitions are being heard together by your Lordship's court.
You are for Aruna Dalai.
I am for the developer.
Sandeep Construction.
Sir, I am the complainant. In person to my complaint, the order of demolition has been passed. So my item number 4 is my writ petition seeking enforcement of the demolition order. Mr. Bhattacharya is for the developer.
But there are two writ petitions. But we passed an order for demolition. There are two writ petitions. One is for immediate implementation. The other is challenging the demolition order. But item number 3, Unauthorized, that's where the order as the municipality has been challenged. I do not know whether item number 3, the petition is appearing before Lordship's court or not.
Item number 3, who's the petitioner?
It's an Aniruddha Singh Roy.
He is not here. Then we have it on Friday. No adverse orders.
Grateful to your Lordship.
Monday?
Yes, Monday,
When
Lordship.
Monday.
Monday.
He's saying Monday. None appears for the petitioner in item 3. Let this matter be listed along with so and so on Monday.
But Bornago municipality appearance may be recorded subject to my convenience.
None appears for the petitioner. Let this matter.
But is saying, my lord, municipality is saying that they have not yet received any
Acceptance
to the report. Kindly also, if it comments to your lordship.
We'll see that Monday.
Very, as your lordship pleases.
Grateful.
That the municipality appearance may be recorded, my lord.
Yes, Mr.
Grateful
Dev.
to your Lordship.
In Arijit Day for Baranagar municipality.
Grateful, much obliged, much obliged.
Monday.
Similar orders in 3 and 4, Malad.
3 and 4, same one.
I'm grateful.
Yes.
I am for the writ petition, my lord. This is for against the cancellation of my trade license, where the Bidhanur Municipal Corporation produced the records, and my lord directed them to file a report in the form of report, and directed me to take an exception. And the private respondent also used an opposition. And on this ground, my lord, the matter was adjourned. It is returnable today. I have used my affidavit in reply in respect of private respondent number 5. As well as exception in the form of a reply against the Bidhanur Municipal Corporation's report. My lord.
This is that Matara.
Mistando Bhandar.
I appear for the respondent number 5.
My lord, corporation's presence is required. My lord.
I am appearing for the corporation. This is the report.
My lord.
Sorry.
My set of 2 replies, my lord, against the private respondent as well as corporation, my lord.
So sorry.
It is the stand of the corporation is that, my lord, may I take the background, take your lordship to the background first?
Yes.
My lord, it's a writ petition where, my lord, the petitioner's father was in business since 1978 from the same premises. The relevant documents, my lord, are at annexure P1 to the writ petition, where from it appears that my father was running the business from the said premises for since long time. My lord, page 19.
Page 19 is that
1920, my lord. My lord, thereafter, in the year 1998, the present private respondent, who is my landlady, heard from my lord, the mother, who was the owner of the property, gifted the property to the present landlady, respondent number 5. That is why a letter of adjournment was issued to my client in 1998, saying that I have gifted transferred the property, so you pay your rent accordingly to my father. But thereafter, father expired, my lord. My lord, continuing with the business of running the sweet meat shop, my lord. My lord, thereafter, what happened? My lord, the private respondent stopped taking rent since October, my lord, 2024. My lord, I had to approach the rent controller. My lord, at that juncture, my lord, there are several complaints made by the private respondent, landlady, on the ground that heat is being generated and the pollution is being caused because of the running of the oven. It's a single oven which was being run for the purpose of preparation of sweet meat. My lord, thereafter inspection was held. And on that basis of that complaint, since nothing was taken care of, the private respondent filed a writ petition. In the writ petition, I was made a private respondent there. In that writ petition, Justice Amrita Sinha, by an order dated 25th of February 2025, passed an order.
Page 25.
I'm deep problem. Page 25, where from it appears that my license has been cancelled. Since the license has been cancelled, so my lord, as usual, my lord, directed I cannot run the business. What is important here, my lord, page 26, first paragraph 4. The fire license of the private respondent, however, appears to be still valid. Nevertheless, without a valid trade license, I cannot run the business. So it was the observation that fire license was intact. I am making this submission because the private respondent took a point that there was a notice to stop the business, but thereafter the fire license has been renewed and my lord, I was given license. That is why this observation. But thereafter, my lord, I also tried to make submission before Justice Sinha, but the court held that since though it is for illegal cancellation or age-old shop room, paragraph 5, I am reading. So since my lord has specifically observed paragraph 6, as the order of cancellation is not under challenge, it will be open for the aggrieved party to take steps. But that is why the present disposition has been filed. What happened after this? The police authority came to the shop that you cannot run the business because of this. In the meantime, out of desperation, what my client did, I must be candid before your lordship, he applied another by way of my lord through online, but he obtained it. But the moment the police authority says no, you cannot run the business, he stopped the business. This being the scenario. Thereafter, I filed another application against the police inaction. That is also the next item. My lord, if this writ petition is disposed of, that will be my lord. But next, my lord, page 27. My submission was that, my lord, page
Cancellation.
the cancellation. My lord, cancellation is, the reason is due to non-availability of agreement. But I was never handed over any order saying this is not available. I was heard that Bidhannagar Municipal Corporation was hearing the matter. When the order of cancellation came to my hand during the course of hearing in the earlier writ petition on 25th of February, what it appears to me that it was passed under West Bengal Municipal Act 1993. Though the Bidhannagar Municipal Corporation issued license, they issue licenses under, my lord, West Bengal Municipal Corporation Act 2006. But that is the license that will also depict from the license I have annexed also.
Page 27.
Page 22 also.
Or the license
22.
that's September, 14 September license.
Yes.
No, it's okay.
So, my lord, an authority which is, my lord, governed by the West Bengal Municipal Corporation Act 2006 issued licenses, and the time of cancellation, he is, my lord, using a provision of law which is not in force for the purpose of that particular municipal corporation. That was my first submission. So on this ground itself, this order of cancellation should be set aside. The report which was filed by the Bidhannagar Municipal Corporation as per your lordship's direction, this report does not highlight this aspect. They are silent about it. They only stated that I appeared. Yes, I appeared. I appeared before the auditor who held the hearing, my lord. Thereafter, the auditor, my lord, asked for the document. I showed the document of this letter of adjournment and my other licenses which I obtained regarding the fire license, FSSI license, and the trade license, and also the litigation which was going on at that point in time. Subsequently, the situation developed. I am protected by the Honorable High Court, the learned civil court's order, whereby my position has directed not to be disturbed. But that is also part of the supplementary affidavit I have filed. One supplementary affidavit I have filed annexing those documents. But when the hearing was held, that time civil court order was not there. Well, at that time, I was only having that I have initiated a proceedings before the learned rain controller. My lord, kindly see my supplementary affidavit once. It was affirmed, my lord, on 16th of May. In the supplementary affidavit, my lord, But kindly comes to supplement, if I, my lord, got it, my lord, the supplementary
yes.
affidavit, my lord, page 5, my lord.
Yes.
Page 5 is the supplementary affidavit. This document I could not produce, that is, my lord, RC case number, that is rent controller case number 1 of 2025. And if my lord kindly sees the page 11, it was affirmed on, my lord, verified on December 2024, and it was subsequently filed in the month of, my lord, it was an item, my lord, it is the first matter registered in 2025. In January, it was filed. So at the time of hearing before the, my lord, the learned officer, my lord, that my lord, document was produced. My lord, the subsequent documents which are annexed with the supplementary affidavit, these documents I could not produce because these are subsequent events. So my argument, my lord, my submission before your lordship is, my lord, is that the authority who was, my lord, guided by the guidelines of the Vidhannagar Municipal Corporation and the regulation and the other directions, that a trade license cannot be issued to a person who is not having a letter of consent or letter of, my lord, or other authority by the, if he is not the owner, by the landlady or the owner of the building. My lord, the authority did not consider this aspect where the parties are at loggerhead. When the litigations or the other disturbing situations are being going on, and there must have been some process of inquiry whether the person is in business or not, or he is a rank trespasser for 1 or 2 months he is coming, or he is coming from the day when the complaint was made to the authority by the landlady or the landlord, that since that is he is the miscreant, he is doing so, and all of a sudden he is trying to grab my property by way of this. And this type of trade license should not be allowed to them because that will take it as a shield. So on that score, that account has not been taken care of by the authorities who had promulgated subsequent notifications or regulations, which the corporation is thinking that later or the written consent is to be given. That situation has not been taken care of, like me, my client, when the person, his father was in business since 1978, and the document supports that, and I have a pending litigation of rent control proceedings before the authority is taking up the matter for hearing, my lord, which proves that there are disputes. But under that circumstances, the report does not say anything. Only the note sheet says only one line. My lord, kindly see the report which is filed. Report copy which is filed by the Vidhannagar Municipal Corporation and was supplied to me. My lord, kindly see page 9 of the report, my lord. Report of the Vidhannagar Municipal Corporation, that is in the form of an affidavit, my lord, in respondent number 224. My lord has got it.
Yes.
My lord, kindly comes to page 9.
Yes.
That is the, my lord, the manuscript in a written handwritten form.
Yes.
My lord, kindly see the second last paragraph, last line. My lord, seeing that the violator Sri Ram Kole carrying out the commercial shop without any agreement with the complainant landowner since long time. So my position of staying there for a long time is not in dispute. But they visited the property also. Well, this being the position, but I'll be beseeching your lordship, but that apart from the other facts that my lord, this recording has not been done and other thing, but the point is very short in this petition. It's a very short. Is that whether they can take the shield of not getting any agreement with the landlady or the owner, any trade license can be cancelled without considering the fact that there are pending litigation between the parties.
Yes. Yes,
My lord, if my lord is on the report, then I'll take your lordships to one page, my lord.
yes.
That is page 10 is the order the authority is relying upon for the purpose of cancellation.
Notification 30th.
Yes, yes, my
30th.
lord. My kindly comes to page
That-
12, page 12, clause number 12.
That's what
That is the
I was
only
reading.
clause they are relying upon. My kindly see the
That's
clause,
what I was reading, sir.
my lord. The clause is very simple. If
And
authority-
malified fake document,
yes,
misrepresentation.
fraud, malafide carrying on. My lord, there is no order does not reflect any such act of fraudulent act. Or I have uploaded any document which is a fraudulent document, which is a manufactured document. On the contrary, their finding is very clear that I could not produce any agreement between the land owner of the property and myself. With deepest of respect, my lord, these type of, my lord, activities, my lord, should be, my lord, taken care of, and my lord should find out the truth after lifting the veil in between these litigations. That, my lord, what is appearing that there are other shops which is still running in the same premises just beside my shop. I have taken one photograph. I could not annex it. Suddenly it came to my mind. But that document shows, but this photograph shows there is another shop which is being run from the same premises, ground floor. Reply to dewa ache? Oh, I have annexed it in the reply. I stand corrected. My lord. In the reply, I have annexed the document. Yes, my lord. My last page, my last annexure to my reply, page 7 of my reply. I stand correct. So it's not that it's a residential property which is being used as a commercial. Yes. If my lord allows me to, my lord, place only 2 lines only in
Yes.
addition. My lord, report, my lord, page 9 of the report.
Yes.
May I read it out? The submitted documents verified by the building plan department, and it has been found that the two-storied building plan vide such and such, dated such and such, issued by the Rajarhat Gopalpur municipality. That is the municipality which was prevailing then. Subsequently, it is merged with the Bidhannagar Municipal Corporation, my lord. Rajarhat Gopalpur municipality found to be genuine, and the shops are allowed in the said premises in question, which has been reflected in the sanctioned building plan. So, my lord, in the sanctioned building plan itself, it carries the existence of the shop. My lord, it supports my contention that my father was in business, and at the time of rebuilding also, when, my lord, in 1998, when they got the property by way of, my lord, the deed of gift, at that time also my shop room and another shop room which is, my lord, annexed to my reply to this opposition, my lord, it also shows that there are another business which is running beside my shop. So existence of the shop and the nature of the building, well, it only proves or leads to one conclusion, that the business is not a new business, or I am not a trespasser in the said business. Just because of litigation, I could not produce any document or agreement. Because a man of ordinary prudence, anyone can understand when the person who is trying to evict me by hook or crook, by any means, but he cannot give me no objection so that I can run my business.
Yes.
But I think, my lord, that is, my lord, sufficient to, my lord, establish that the corporation, my lord, the action is required to be revised, my lord, revisited, my lord, by your lordship, and it is to be rectified so that I can run, my lord, run my business from the shade shop. My lord. That's my humble submission before your lord.
Yes, Mr. Bandyopadhyay.
Lord, we have filed a report.
Yes.
Your lordship kindly takes it.
Yes.
Lord, kindly takes paragraph 4 of my report. Paragraph 4 of my report. That upon receipt of the complaint, an inspection was conducted by the officers of the BMC on so and so. During inspection, Ram Kole was found operating the sweetmeat shop under name so and so. During the said inspection, the officials of corporation had specifically directed the petitioner to furnish all necessary and relevant documents, including the tenancy or rent agreement, owner's consent, and other supporting documentation required for continuation of the trade line. Where it is written, it is required, I'll show. Despite such direction, petitioner failed to comply. Then kindly take 6. At the time of hearing in connection with the written complaint lodged by Gargi Goswami, it was submitted by the complainant that the petitioner hearing was conducting the commercial business activities from the said premises without holding any valid rent agreement or legal right of occupation. It was further submitted that the trade license in favor of the petitioner had been obtained from the so-and-so portal on the basis of incorrect and unauthorized declarations, and complainant prayed for immediate cancellation of the same. Then Malat adjournment was paid, etc. Kindly takes paragraph 7. That on the said date, both the parties appeared before the concerned authority, and during the hearing, the complainant submitted a photocopy of the sanctioned building plan of the subject premises, which upon verification was found to be genuine and duly approved by the Rajarhat municipality. The petitioner, however, this is important, failed to produce any rent agreement, occupancy certificate, or any document evidencing legal possession of the premises. After considering the materials on record and in the absence of valid tenancy or ownership document, the BMC directed the trade license cell to initiate proceedings for cancellation of so-and-so. According to the corporation, under clause 12 of the notification number so-and-so of 13th September, issued by the so-and-so, cancel the trade license. Now, my lord, if your lordship kindly take this notification of 13th September, but before that only one line I'll add. My lord, this trade license, my lord, is in the system of self-declaration. One can go in the portal, get it, but it is subject to physical verification later. It's much like our tax that we submit, self-declaration. Kindly takes page 10 of the report. Kindly takes second paragraph.
Yes.
For the context of the notification, this is by the UDMA department, that whereas second paragraph at page 10. The services and the web portal of online issuance of trade license, along with registration under shops and establishment through common application form, has been launched on so-and-so, and the services have been made go live with effect from so-and-so. So this is pertaining to online trade licenses. Now kindly your lordship will be pleased to turn over to page 11. Serial number 2. The documents which I mentioned, Mala, submission of only 2 documents, which is identity proof of the applicant and proof of occupancy, ownership of the business address, property tax bill, receipt, deed of conveyance, lease deed, sublease deed, leave and license agreement, rent receipt, NOC, if rent is free, electricity bill, telephone bill in respect of the place of business and the name of the applicant will be required. Well, under this notification, we have asked for the document. He has failed to do so, Malad.
No, that's what I'm saying. That when you read this number 2, one is proof of occupancy. It's not in dispute that he's not the occupant. There's an order in his favor which shows that he is the occupant. The other document which is required is ownership of the business, not required. Deed of conveyance, deed of lease deed, sublease deed, leave and license, rent agreement. And then rent receipt. He's paying the rent receipt before the court. So these documents are there, Mr. Bandyopadhyay. This has not been taken into consideration. In terms of your own notification, if you see the impugn order which is under challenge here, which is page 27. Page 27.
You don't know. It is-
And even as far as your own
Actually,
page 27 is that one line order, but even if we look at the hearing which you have conducted and the manner in which you have passed the order on page 9, last paragraph.
well, page 27 of the writ petition, your lordship.
Page 27 of the writ petition is the impugned order, but the background to the order is page 9, where you have given the hearing and recorded your reasons for cancellation of the trade license. Even there, if you read in terms of notification dated, which you have just read out, and under the facts and circumstances, the undersigned direct the violator to stop the illegal business at the subject premises and also to cancel so and so. Right before that, if you see page 9, second paragraph, at the time of hearing, the violator Shri Ram Kole failed to produce rent agreement. So it is not only rent agreement. It is other agreements, documents which have to be taken into consideration.
But
In
perhaps,
terms of your own notification.
but perhaps the issue here is that.
And then you further read page 12.
My lord, your lordship is perhaps reading from the other writ petition, my lord. My lord,
The
we
first one.
are in 7128.
7128.
7128.
7128.
ছোট রিট ওটা নয় যেটা পাতলা রিট পিটিশনটা আছে
It is 7128.
The report which you have filed,
Yes,
I'm
my lord.
reading page 9 of
My
that
lord.
report.
Yes.
If you will have page 9 of the report, this is the order which has been passed after giving him the hearing. The second paragraph of page 9, this is the reasoning, the grounds on which you have
At
rejected.
the time
it.
of hearing.
Yes. At the time of hearing, the violator, she so and so, failed to produce the rent agreement with the complainant. So this is the only ground which you have taken
Right.
into consideration. In terms of your own notification dated 13th September 2021, this is not what it is reflected from para 2, which you have read out. Then page 12, if you go and read clause 12, ULB is authorized to cancel the certificate of enlistment immediately in case of detection of any fraud, malafide data entry, uploading of any fake document is to be detected.
Yes.
All right. 1, 2, and the third argument is if you see the certificate of enlistment on page 22, this has been issued under the 2006 Act, all right? And the cancellation, if you see, is under 1993 Act. This is the third limb of the argument. So this has to be reconsidered.
No, 19, that act, statute, my lord, this statute, once it is merged with
Okay,
the
I-
authority, the.
All right,
statute will cover.
I'll take that argument of yours. But as far as just one, it's a non-speaking order. It's absolutely a non-speaking order. This has to be remanded back. You hear the parties, pass a speaking order.
My lord, as on the date, if your lordship sees, my lord, if I've understood it correctly, my lord, when they had applied for the trade license, my lord, perhaps they were not in seizing of any of these documents.
See,
Whatever
Mr.
documents are being
Bandyopadhyay, the
produced,
only thing which is mentioned here is the rent agreement.
rent agreement.
They were in ownership. They were in possession. That is not disputed. They were in possession. No, they were in possession, sir. Possession is not disputed. Even at the time of inspection, you found them in possession. They are
They
in
were the occupants.
occupants.
But the authorized occupancy is not proved. But
You
your lordship
consider-
will see it is proof of occupancy.
There is nothing which has just rent agreement is not only the ground. The rent receipts are also there.
Well,
Even if we say that, subsequently the order has been
what I was trying to impress upon is that, my lord, one is if you are in occupation, you will get it, like an electricity connection. But the other thing is that to prove the occupancy, meaning
they had
that
rent receipts.
the authorized occupancy, not
Author-
unauthorized occupancy.
Consider all this.
There is no sanction.
Yes, sir.
Use it for commercial purpose. আমি আগেরটা করেছিলাম।
আরে এখানে পয়েন্টটা নেওয়া নেই।
I have certain facts to point out.
Yes, yes, please.
Lordship has heard
এখানে সেই
the
পয়েন্টটা
learned
নেওয়া নেই, লজ্জা, সেটাই বলছি।
petitioner and Lordship
যেটা বলছে সেটা
named
শোনো।
No, this is not opinion. This is what
Well,
I can see. You can change my opinion.
Prima facie.
Prima facie.
Lordship, may I correct certain foundation
Please do.
facts. My lord will first kindly come to page 20 of the writ petition. Page 19 and 20. But the entire matter, the case made out by the writ petitioner hinges on the fact that he was in occupation. His father was running a sole proprietorship business from the property from 1978 and had a valid trade license. Now, my lord, page 19 and 20 are used as the only evidence to demonstrate this. Now, if Lordship kindly takes a closer look at page 19, it's not very legible. Lordship will kindly see the premises number.
AB 28.
28. Now, again, Lordship may kindly come to page 20.
No, this is not in dispute that they are not in occupation right now. They
Malad-
might be illegally in occupation, but they are in
Malad,
occupation.
may I please point out the problem?
Are you saying they are now
It's
not
a
in
different premises. Mine is AB 24. He has given AB 28. And that's not the only problem with these two orders, Lordship. I'll come to one by one. Lordship will see this is not only a manufactured document, it's very suspicious.
Page 20.
Malad, may I, Lordship, I did not interrupt my learned friend. Page 20 of the writ petition. Now, Lordship will see AB 28. It is not in dispute that this entire matter concerns AB 24. Now, Lordship kindly comes to page 20, bottom of the document. Well, very interesting, my lord. Even if manufactured, amateurish job. Lordship will see that the validity of this license is till 31st March 2000. Now, Lordship will see below that, when has this license been issued? 2nd November 1999. My lord, I am not aware of the municipal authorities issuing a trade license for 4 months. I'm not aware of any such instance ever. That's the first instance, Lordship. Now, Lordship will see in the next writ petition, which the same writ petitioner has filed, he has made an identical pleading, but has annexed a different trade license. For that, if I may draw my lord's attention to WPA 6458/2025. Identical pleading, it's para 3B in both the writ petitions.
page
26 of the next writ petition, Lordship. But the pleading is exactly the same, that this is his only evidence to show his father was running a sole proprietorship. Now, Lordship will see the address. Part of premises FB 28. We are concerned with AB 24. This is an entirely different premises. And now yet again, more interesting. Lordship will see due for the half year ending 31st March 1997. Now, Lordship will see certain parts appear to have been erased with a whitener and certain changes have been made. This document is issued on 16th January 1996, valid till 31st March 1997. But if I may put my submission in the form of a question, has your Lordship come across, because I have not, a trade license being issued for 15 months, one trade license issued for 4 months, one trade license issued for 15 months? Both, one is AB 28, which is not my premises. One is FB 28, which is not my premises. And the pleading is identical in both the writ petitions, that this is only evidence to prove that his father was running a sole proprietorship firm. And on both occasions, he has pleaded that his father was running this sole proprietorship from the year 1978. Now, Lordship will see under which act are these supposed trade licenses issued? The 1993 Act. On the first blush, the very inception of his case, even if I assume these documents are not manufactured, they clearly appear to be manufactured, because I've never seen of such an instance, a 4-month trade license, a 15-month trade license. And even if they be true, they pertain to entirely different premises number. And Lordship, to satisfy my lord, Lordship will kindly come to can 1 in the first writ petition, which is 7128. We filed a demurrer application, Lordship. We'll see can 1, page 59. We'll come to that. Well, it will kindly see page 59. This is the schedule to the writ petition which I had filed because he was running this shop without any clearances. Well, that is can 1 of
The
2020.
only high court where we don't have running pagination.
Well,
You know this, right?
well, I believe it.
You must have appeared in other high courts. Have you seen a high court where there are no running pages in the files?
No,
Like you have a no, running pages. Like counter,
number.
writ petition, counter affidavit, rejoinder, and they're all running pages. Not like writ petition has till 40 pages, and then
Like
the
a
counter
paper
has
The paper book split it.
so difficult to figure out. How do you make submissions without running pages? It is mentioned in your
But when we file the paper
in your
book, it's-
practice direction, it is there, but nobody follows it.
But when we file the paper book, it's a running page number. But
Paper book, yes.
in the paper book,
Yes,
when we file
but
the
only in
paper
the paper.
only the paper book.
Yeah, but here, one page is here, the other page is there.
But if it is there in the writ rules, my lord, I might have missed it. I have not.
It is there. I've seen.
I'll check it.
ये निकालो भाई can.
Can 1 of 2025 in 7128. To can 1 to bar kore din, amra bar kore din.
And generally the files are like, you have the writ petition, then you have
Everything tied together. So
in sequence too.
Can 1.
In sequence.
yes, that part is beyond our control.
I know. No, I'm just saying that it's so difficult for lawyers or the judges. Yes, what are you
Lordship
trying-
has the schedule at page 59, Lordship.
Yes.
Well, it will kindly see the premises number, more or less lying and situated at AB 24. And I'm not pointing it out, but I can, Lordship may take my word for it. All throughout his own pleadings, it's AB 24 as far as the present dispute is concerned. So this entire factual basis of his case is incorrect, 1, and 2,
Sir, the trade license is issued in which premise?
AB 28, as he claims.
No, the next, today, what is under dispute?
Well, at AB 24.
So we are dealing with AB 24. All right. All these arguments you can raise before the
Well,
municipality too.
Lordship, but there are further factual aspects.
These disputed questions of fact, even the petition which is pending, the eviction suit
Lordship,
which is pending,
Lordship.
you can raise all this. But as far as the issue which is before us regarding the cancellation of the trade license,
Lordship,
how is this relevant?
That can be.
I can understand that you are saying that AB 28 is what the father had actually stated. So there's a dispute. So as far as the ownership is or the occupancy is concerned, that is under cloud.
Lordship.
Right?
Lordship.
That can be an argument.
Lordship.
But then subsequently, today, what we are looking into is the trade license. Trade license is issued in AB 24.
Lordship.
Which is before this court.
Lordship. Grateful.
All these arguments you can make before the municipality.
Now, my lord, as far as the rent agreement is concerned, may I try and satisfy my
rent agreement? There is no rent
may I
agreement initially probably was there with the father or maybe not.
Never there, never, not
Yeah,
a scrap of
that
paper,
is, sir,
not a scrap of. Lordship, what?
Let me be very clear. As far as the notification of 13th of November 2001 on which they have relied and passed this order is concerned, it is not only confined to one document, which is your rent deed. but it is confined to many other documents which can be given by the person concerned who's seeking the trade license.
My lord.
It is for the authority concerned to see whether those documents are sufficient enough to grant him a license or not.
Grateful.
All right.
Yeah.
Since in this matter, there's only one document which has been taken into consideration at the time of passing of the impugn order,
My lord.
which I think is in contravention with the section which has been read out or the clause which has been read out.
Now, may I try and satisfy my lord on the factual aspect of documents?
Yes.
My lord, in this case,
I'm not stopping you from making a submission.
no.
I'm just telling
It's
you
very, lordship, it is
what is
very
my
helpful.
view.
My lord, lordship, it is very helpful if lordship expresses his mind, because then it allows us to clarify these aspects.
Yes.
My lord, in this case, the petitioner did not have a scrap of paper, my lord, not just this document, no document, at the contemporaneous juncture.
But
All these documents.
What about the rent receipt? See, you were receiving.
No rent receipt, lordship.
No.
No rent receipt. My lord, kindly.
Ms. Goswami was receiving the rent receipt till 24, right?
My lord, we are
Then
not aware.
subsequently he started filing it before the rent control.
Lordship, that is not correct. That is what I want to satisfy my lord. There is no rent receipt which is annexed to the writ petition. One, this entire submission is disputed. Two, the taking out of a trade license which was cancelled, as also the approaching of the rent control were done belatedly after I initiated proceedings before the competent authorities, and they were all obtained on the basis of a self-declaration where you would have to give certain documents. He has given none because he could not have had them. After I started making the complaints, he started generating through self-declarations one document after another, which includes a trade license and a fire license. He still does not have the other documents which are required in law to carry on business. Lordship will see the governing provision in the Municipal Act. It says that obtaining of a trade license will not confer on the applicant a right to run a business unless you don't have the other licenses required in law.
Notification also says that.
Grateful, Lordship. He has none. No GST registration, no file license at the contemporaneous juncture. After I filed the writ petition, her ladyship passed orders. Did he surreptitiously obtain these licenses through self-declaration unilaterally? So all these documents are belated, obtained through fraudulent declarations, because he did not have any of these documents. Now, rent control. When did he approach the rent control? But the submission was made that after I refused to supposedly accept rent, of which he has given no evidence, he approached rent control. That is ex facie incorrect. By his own admission, he approached the rent control in 2025. Now, Lordship will see, when did I institute my writ petition? 2024. I instituted these complaints from August 2024, when, using all goons, political influence with ruling or whichever dispensation, he was trying to dispossess me, pressurizing me to sell the property. I was under threat. These facts were brought to I filed the writ petition. These facts were brought to the notice of the Honorable Court. The Honorable Court took cognizance of these facts and directed the police to give me protection. Thereafter, the police gave me protection. But I filed all these complaints before the Pollution Control Board. He does not have a clearance. He's running a manufacturing activity, no clearance. From August 2024, those are annexed to my can. Therefore, under such circumstances, Lordship, the question arises, at the contemporaneous juncture, if he does not have a scrap of paper, was he even entitled to get a trade license in the first instance without any contemporaneous document? Now, after I initiate all these proceedings, he goes and obtains through self-declaration a license, and then can he use that to now say that this will show that I had a document? But then at the contemporaneous juncture, you did not have a document. What document could he have produced to obtain this license, Lordship, if I may ask myself this question? None. If, Lordship, all the submissions made by my learned friend were to be true and correct, would he not have annexed those documents? And I've shown the only document is that those two trade license pertaining to a different premises, where even the license number has been removed with a whitener. So therefore, Lordship, at the inception of the matter, he was never entitled to a trade license. And Lordship, what I submit is backed by the judgment of the Honorable Division Bench, which I may kindly place the relevant paragraph. Because this same argument, which is being advanced before your Lordship, was advanced before the Honorable Chief Justice.
But he has not gone into that issue.
Malad-
That is
Malad-
also annexed with the
Lordship,
report which they have filed.
Lordship, there are observations with respect to this argument made by my learned friend. It was argued on our behalf that since the trade license has not been challenged, I mean the cancellation, he could not challenge the cancellation in the appeal itself. So on that ground, his Lordship was pleased to dismiss the appeal. But as far as this argument being advanced before your Lordship, the same argument was advanced and dealt with by his Lordship, the Chief Justice. May I place the order? Lordship will kindly come.
With
Malad-
the report they have filed, they have placed the order. The same
Malad-
order, right?
Lordship, the division bench's judgment, I want to show only that paragraph where this aspect of the matter was dealt
This is
with.
WPA 30997.
That was my writ petition, and the appeal is MAT 304 of 20.
304 of 20.
Lordship.
They
And
are
it's page 165 of our can. I'll show it from the report, Lordship. I'll show it
you are
from the
reading
report.
paragraph 4.
Lordship, I'll place the paragraph. Lordship, I'll place it from paragraph 2.
Paragraph 2. Okay.
May I just place only
Page 17.
that will be Lordship page, grateful to my learned friend Lordship, it's page 17. We have elaborately heard the learned advocates for the parties and carefully considered the materials placed on record. The sheet anchor of the argument of the appellant is based on the license obtained from the Bidhannagar municipality, the Department of Fire and Emergency Services, and Food Safety Department. Now, Lordship, kindly note the next line.
I've
To
noted.
be noted, all these licenses are fresh licenses which have been issued pursuant to online applications made by the appellant. The license issued by Bidhannagar Municipal Corporation has contained a disclaimer stating that the license is auto-generated through computer system as per data submitted by the appellant himself in online procedure. Respective department may verify the documents, credentials from the certificate holder if so deemed fit. Therefore, nothing stems out from the certificates issued through online application based on self-declaration. Much after the fire department issued the online license, which was valid for the period from 9th October to 8th October 2025, there appears to have been conduct of an inspection, and the West Bengal Fire and Emergency Services has passed an order on 18 December 2024 by serving a notice under the Fire Services Act, directing the appellant to stop the function in the appellant's establishment, failing which legal action will be taken against the appellant in accordance with the various provisions of the Act. Now, Lordship, this order has not been challenged till date. In fact, unless all these orders and all the other clearances are received, let me assume that the trade license is set aside. It will be of no benefit to the petitioner. It cannot be. But coming back to the foundational argument, how did he even obtain it without a scrap of paper? That is the question, which is why we had submitted before the concerned authority that the trade license could not have been issued because he did not have any document. So rent control, license, all this first obtained after I initiated proceedings before all these concerned authorities. Rent control approached after I approached this honorable court in the writ petition, and when her ladyship was hearing the writ petition, the hearing was on. Without informing anyone, they went and surreptitiously approached these authorities. So therefore, the issue of rent agreement not being the only document and other documents being there, Lordship will kindly see that there were no documents. He has not annexed any rent receipt. He has not annexed any previous agreement. He's an agreement holder from 1978. Where are all the previous agreements? It's not a case of him getting it from a third party. It's his own father as per his own case. Where are those agreements, Lordship? We would all like to see. That's the one thing. The other thing is, this claim is based on a sole proprietorship firm. Lordship knows it is settled law that there is no concept of a perpetual succession in a sole proprietorship. Let me now, on a demurrer basis, assuming without admitting that his father was running this business. Now I come to the last limb of my submissions. Assuming without admitting that his father was there in the property running a sole proprietorship business, the moment his father passed away, he became a complete stranger to the premises, because by operation of law, there is no concept of a perpetual succession. Lordship, on the last occasion when Lordship was hearing the matter, my lord, I had submitted that I would place two judgments, one of our honorable court and one of the honorable Supreme Court, which records this. If my lord wants, I will place those judgments. But since it is such a well settled concept, I ideally would not like to cite a judgment. So therefore, even if tenancy was granted to a sole proprietorship, being the son, he's a nobody. As a matter of law, there's no fact involved here. It's a matter of law. Therefore, he'd automatically become a stranger. Therefore, one, no proof that he was there. Number two, he obtained all these declarations after I initiated proceedings. Number three, he went to rent control after the writ petition was filed. Number four, he obtained the trade license on the basis of nothing, because there's no rent receipt issued annexed to this writ petition. And Lordship, number five, even if I were to grant him the benefit of doubt on all these points, he's still a stranger to the premises, because his father, that was a sole proprietorship firm. He also claims to be a sole proprietorship firm. Therefore, on pure matters of law, he's a nobody. And lastly, Lordship, even if all this is taken to be true and correct, even I grant him the sole proprietorship argument also in his favor, even then, unless he acquires all valid licenses in law, even under the Municipal Corporation Act, he is not entitled to run that shop without obtaining the other licenses. And last but not the least, he has not challenged the order of the fire department as noted in the judgment of the Honorable Division Bench, directing him to stop operations. How can he resume operations? By getting his trade license cancelled, by cancellation even set aside. Therefore, Lordship, these are... My lord, in that case, if this would be the argument today, Lordship, these requirements are there in the municipal statutes because some degree of sanctity is to be given to the owner of these premises. This is not a case of a residential premises where a person is a tenant or a lessee, or where I want to evict my lessee who's residing there. That is why certain protections in law are given, that I have to evict in accordance with law. Till that time, you give him the benefit of the doubt. For, let's say, electricity connections, he still would get the benefit of the doubt. But this is running of a business, Lordship. It is not a case of a residential property. Therefore, without a scrap of sanction from the owner, a scrap of previous documents from the owner, he cannot maintain a trade license from the municipal corporation without a scrap of paper and through documents generated belatedly. No previous trade license shown in respect of the premises. No previous rent agreement shown. No rent receipt. No rent control. Everything after I initiate proceedings. Lordship.
In the other rate, 6548, you have filed a can. Who has filed a can?
Lordship, we have filed a can on a demurrer basis, taking all these points.
In that can, there's a document
Lordship.
at page 164. What is that document? You say that you don't even know him, right?
No, Lordship, I say that he's a trespasser. That's my case. And there are civil proceedings pending.
Civil proceedings, sir. You acknowledge him. Page 164, 165. Who's Leela Chakravarti?
My lord,
your mother?
No one connected with me. My predecessor in interest, who I do not know.
Very good. So these are letters of 1980. See, all these arguments which
my lord, all these arguments would come to a sole proprietorship to his father. So, my lord, in that case, may I cite that judgment of the Honorable Supreme Court?
Sir, I'm not deciding civil dispute here.
My lord, but
I'm only looking into the cancellation of the trade license. And
my lord, in the trade license, what is
nothing more.
My lord, there is no scrap of paper to show the petitioner is an occupation. This is all to his father's sole proprietorship firm. As a matter of law, even a legal representative cannot join in a proceeding if the sole proprietorship passes away. The sole proprietor, Lordship. May I place these two judgments, my lord, only for my satisfaction?
Are not relevant, sir.
But because then he doesn't have a scrap of paper to prove that he was in occupation.
Give all these judgments to the municipal authority.
My lord, but kindly records that as per the order of the judgment of the Honorable Division Bench, he is not entitled to resume operations as long as those orders are there in existence.
Yes, he is not. Till the time those orders are there, he can't operate.
Lordship. my lord, may we submit a two-pager note at the
No need.
conclusion? As
My
my
lord,
lord.
two-line reply, my lord, just two-line
Yes.
reply. My lord, page 21 of the writ petition 7128.
Page 21 of 7128. Yes, sir.
Yes. But this is a letter of adjournment issued by Leela Chakraborty.
Yes, yes. This is what I've showed on
Yes,
that
my
page
lord. I'm
169.
deeply obliged. This is a change of ownership.
This is what I've shown, sir. I was showing this one.
My lord. And my lord, the other writ petition kindly comes to page 27. The writ petition 6458.
Tell me what is it?
This is the document of certificate of enrollment contains AB 24 in the name of my father.
Yes, 1980 document, page 164 of the CAN.
164. This is 27. It is much clear. The certificate of enrollment in the name of my father,
Yes.
AB 24.
Yes.
So, my lord, this
This is not a
only
trade
showing
license.
document,
Enrollment.
only showing document to divert and to come to a wrong conclusion, my lord. This should be replicated with defense of actions. I'm deployed.
The petitioner has filed writ petition number 7128 of 2025. This is, the first one is 6428, right?
My lord.
My lord, the first one is
That is the
7128.
police authorities.
Item number,
Right, हाँ.
sir, 71.
Uh,
First one is
6428. ये पहले लिख लो. 6428 seeking a direction upon respond number 2, 3, and 4 not to obstruct him from carrying on his business from the shop situated at 24 AB 24 Deshbandhu Nagar, High School Road, Bagwati, Calcutta, full stop. In writ petition number 7128 of 2025, the petitioner has challenged the order dated 20th February 2025, whereby the respondent authorities have cancelled his trade license previously granted to him for operating the shop operating the sweet shop in the name of Ma Tara. What is it? Ma Tara Mishtan Bhandar. Inverted comma kar dena, Ma Tara Mishtan Bhandar. Full stop. Both the writ petitions arise from the same set of facts, whereby the respondent authorities cancelled the trade license. With the consent of the parties, both the writ petitions are taken up for joint consideration and disposal. Full stop. The case of the petitioner is that he is a tenant in occupation in respect of the aforementioned premises and has been running a sweet shop and manufacturing unit therein under the name and style of Ma Tara Mishtan Bhandar. Full stop. It is stated that initially the business was run by his father since 1978 under the tenancy of one Miss Leela Chakraborty. Full stop. Subsequently, the said property was transferred to Gargi Goswami, respond number 5 herein. Full stop. In 1998, Ms. Goswami reconstructed the said building and reinducted the petitioner's father into possession of the said shop. Full stop. After the demise of his father, the petitioner continued to run the said business from the said premises. Full stop. Petitioner submits that Ms. Goswami had been receiving the rent till August 24, after which she stopped accepting the rent. Full stop. Thereafter, the petitioner began depositing the rent before the rent controller. Full stop. It is further submitted that the landlord-tenant disputes are currently pending before the civil court. Full stop. Learned counsel for the petitioner submits that the trade license has been cancelled in contravention of the notification dated 13th of November. What is the date?
Cancellation, my lord.
No. That notification. September 2018.
It is, my lord, 13th of September 2021.
13th of September 2021. वो कहाँ गया? Can you give me another copy of your reply?
Lord, the report, my lord, I have.
Yes, the report. क्या लिखा है? September 2021. He further states that the trade license was issued under the West Bengal Municipal Corporation Act 2006 on 14th September 2024, which was subsequently cancelled under the West Bengal Municipal Act 1993, which is in contravention of the statute, and that the said provisions were not applicable at the time of cancellation of the trade license. Anything else?
That's
This is it. Learned counsel for the respondent. Learned counsel for the respondent submits that after giving adequate hearing and after giving adequate hearing, the impugn order has been passed. Full stop. Counsel for the respondent states that the petitioners were given the opportunity to produce relevant documents in terms of the above mentioned notification, and that they failed to produce any document, especially the rent agreement, which has led to passing of the impugned order. Counsel for the respondent corporation states that on the basis of the notification, since the petitioner failed to produce any document in support of his application, the respondent authority had passed the impugned order. Full stop. Learned counsel for the private respondent number 5 states that the petitioners are rank trespassers. They have never been in occupation of the said property. They say that they have fraudulently obtained the trade license through online portal. Full stop. He further submits that during the course of hearing before the respondent authority, they had failed to produce any document which entitles them to grant of the trade license. Anything else? I'm not getting into your civil suit. So confine your argument only to
only on the sole proprietorship point, saying that that document could not have been relied on, and Lordship, the other licenses, unless he gets, he can't run. These are the 2 points, Lordship, if kindly, Lordship.
Learned counsel for the private respondent number 5 also states that that at best, even if it is considered that the respondent authorities have illegally cancelled the trade license, the right of the petitioner was only limited to the extent that he was the sole proprietor, and that the same could not have been carried on to his son. The sole proprietor is only entitled, his father, who was the sole proprietor of the said sweet shop, was only entitled for the occupation of the said premises, and that could have not been transferred to his son. That's the argument. That's the argument, sir.
Lordship. It could not have been used as a document to prove the petitioner's occupation in the
that could not have been a ground for the petitioner to claim possession and occupancy of the said property. Full stop. The petitioner landlady had earlier filed the petitioner's landlady, Gargi Goswami, Ms. Gargi Goswami, had earlier filed writ petition number 30 WPA number 30997 of 2023, seeking a direction not to grant any further permission to the petitioner on the ground of potential safety hazards, since the petitioners were carrying out the manufacturing unit also from the said premises. Full stop. Which could have led to fire safety issues. Full stop. During the hearing of that writ petition on 25/2/2025, the respondent municipality informed the Honorable Court that the petitioner's trade license has been cancelled on 20th of February 2025. Full stop. Consequently, the writ petition was disposed of with a direction upon the officer in charge, Bogoti Police Station, to ensure that the petitioner does not run his business from the subject premises without holding / obtaining a valid license from all the competent authorities. Full stop. The petitioner's challenge to the said order before the Honorable Division Bench in MET 304 of 2025 was unsuccessful. Full stop. The petitioner subsequently applied online for a trade license and was issued a fresh license dated 14. This is, what is the date? 14. Trade license was issued on
Subsequently.
14 September 2024.
Malad, the subsequent license, Lordship, is 28th February 2025. That's
28th
page-
February or 14th? Page 22.
The first one is, Lordship, September, which was cancelled, and thereafter, during the after My Lord Justice Sinha's order,
Yes.
he got a fresh online self-declaration license on 28th February 2025.
28th February 2025. 28th February.
And the division bench's order was after that.
Through an automated process. As his other licenses remained valid, the petitioner attempted to reopen his shop. Full stop. However, on 11/4/2025, when he made the said attempt, he was allegedly prevented by the police authorities from operating his business. Full stop. The petitioner has challenged the action of respondent number 234 in WP 6458 of 2025. Full stop. In WPA number 7128 of 2025, he assails the cancellation of his earlier trade license dated 20th of February 2025. The petitioner submits that on the basis of complaints filed by Ms. Goswami, the respondent authorities held hearing on (13/1/2025), 4/2/2025, and 17/2/2025. Full stop. However, no formal order was issued following these hearings. Full stop. During the proceeding before this court on 25, hearing was on 25/2/2025. 25, the municipality produced a one-page cancellation order. Full stop. The petitioner contends that the said cancellation only discloses the reason for his cancellation is that he failed to produce the rent agreement. This is the only ground?
My lord, rent agreement.
That's the only ground of cancellation, right?
Only ground of non-availability of agreement.
He has failed to produce his non-availability. Rent agreement. Failed to produce the rent agreement. Full stop. This court has heard the submissions advanced by the counsel for the parties as well as perused the materials on record. Full stop. From a plain reading of the impugned cancellation order dated 20th of February 2025, it is evident that the respondents cancelled the trade license without assigning, have cancelled the trade license with only an observation that the petitioner has failed to produce the rent agreement. Full stop. Going by the notification dated 13th of September 2021, wherein clause 2 of the notification reads as under. Full stop. In view of the said clause, it is noted by this court that the non-availability of rent agreement could not have been the only document for the respondent authorities to cancel the trade license. The notification itself reads that the petitioner is entitled to place other documents in support of his application, which shall be considered by the respondent authority. Further, the notification, clause 12 of the notification reads as under. From the mere reading of the said clause, it is apparent that the trade license shall be cancelled only upon detection of any fraud, malified data entry, uploading of fake documents, and that none of the said facts are attracted in case of the petitioner. Full stop. The respondent authorities have failed to pass a reasoned or a speaking order in terms of their own notification. Full stop. In view of the above, the cancellation order dated 20th February 2025 is hereby quashed and set aside. Full stop. The respondents are directed to conduct a fresh hearing and pass a reasoned order after affording an opportunity of hearing to the petitioner as well as the private respondents within a period of 4 weeks from the date of communication of this order by way of a speaking order. The full stop. The said order shall be communicated to the petitioner within 1 week thereafter. Full stop. Since the petitioner's trade license has already been revoked by the competent authority, this court does not find any illegality in a respondent's action of preventing the petitioner from operating the said shop. Full stop. Until such time, the petitioner obtains a valid trade license and all other licenses from the appropriate authorities, he shall not be permitted to conduct business from the said subject premises. Full stop. In the light of the above observation and findings, WPA 6458 of 2025 is dismissed and WPA number 7128 of 2025 is allowed to the extent indicated in the above order.
Only one indulgence, if your lordship so pleases.
Yes.
Since I am without business, cannot run the business, so the time limit of 4 weeks, that mandatory, my lord, so that they can complete it within that time.
They will.
My lord.
Any order of the court they have to comply with. What mandatory?
Yes.
It is mandatory. Every order passed by this court is mandatory.
And my lord, only one thing is that, my lord, during course of hearing, my lord, both the parties are at liberty to produce records, my lord, documents, my lord.
That goes without saying, sir.
Grateful Lordship. Lordship, may I express one sentiment if Lordship permits?
Yes, sir.
My lord, we relative juniors, we crave for an opportunity where a court gives us a patient hearing. Lordship has heard us just as if Lordship would hear any other senior counsel. Lordship, we're extremely grateful. Lordship has given us this patient hearing.
I personally always feel that, because
extremely grateful.
We were also on the other side.
Lordship.
And I always feel that the juniors should always be given the opportunity.
Lordship. Very grateful.
Full opportunity.
Grateful. Very grateful for that, Lordship. Grateful.
Yes, next. Oh, I'll just take a break for 5 minutes.
May I take back the report, the additional copy that I have?
Oh, yes, sorry. I couldn't find it at that point of time. I'll give it back to him. It must be in the record, but I was not able to find it. Just give it back to him. Give it back.
Well, item number.
I beg to appear on behalf of the Director of Local Bodies.
My lord,
I am for the municipality hearing, my lord.
Yes, Mr.
I am appearing for the petitioner.
Yes.
My lord, 12 councillor before your lordships. My lord, there is twofold
Well,
allegation.
only well, before my learned senior friend starts, my lord, man, I'm not intervening in this argument, my lord, only because there was a direction to file an affidavit in opposition. Well, we are ready with the affidavit in opposition.
And
Your
also
lordship
you
kindly accept.
call for a report from respondent number 2 and 4.
Well, there was no
My lord,
specific.
whether-
There's no specific
No,
direction to file a report,
your
but I've
lordship-
taken instruction, Lordship,
your
if
lordship-
I may submit.
in open express your
Yes, Mr.
lordship's open mind.
Yes.
My lord, on the earlier date, there is
Yes.
twofold allegation against the my lord chairman
Yes.
that without
Embezzlement was there.
my lord, no, yes, my lord, without my lord approval of board of meetings,
Funds were being.
funds and already money, my lord, disbursed from the my lord municipal fund, and my lord, there is certain document has been forged by the chairman itself. And my lord, there is totally violation, my lord, without budget, my lord, fund cannot be out from the municipal. That has been done by the chairman itself.
Yes.
My lord, that allegation before the my lord, respondent number 2 and 4, they are not looked into. That's why read petition before your lordship. That's why your lordships also express your mind, lordship's mind that report may be called for from respondent number.
May I submit, Lordship?
Yes.
Whether my lord,
Lordship, as per section 82 of West Bengal Municipal Act, a copy of the budget estimate adopted by Board of Councillors shall be sent to the Director of Local Bodies for information and shall be available for inspection by the members of the public in the manner prescribed.
Yes.
Lordship, by a letter dated 2nd June 25, the Chairman, Krishnanagar Municipality, requested the Director of Local Bodies to incorporate a few capital stroke deposit works to the existing annual budget estimate for the financial year 25-26. Lordship, in reply to that, the Director of Local Bodies has asked them to clarify whether budget estimate for financial year 25-26 placed on 7 March 25 was duly adopted by Board of Councillor, and if yes, it is requested to send a copy of the same to the Director of Local Bodies, but they have not sent any report to the Director of Local Bodies. That is my instruction, Lordship. I have asked for the letters also. If Lordship may
My lord.
permit, I can file those reports on the next date,
I think
Lordship.
it's also, my lord, under the Prevention of Corruption Act.
Mr.
My
Monty,
lord,
it's
your
better.
lordship, my lord, call for an inquiry report from the SP that what, my lord, document has been forged by the chairman.
First, let the report come from
Yes.
the.
Well, before your lordship passes any order, well, I'll take your
Yes.
lordship's 1 minute time, my lord. Well, I have.
My lord, in
as
the
a-
meantime, my lord, kindly see the one section.
Well, I.
Your lordships know,
I'll hear
Lord,
you.
my lord, section 60,
2006 Act.
69(2).
What
No
2000?
payment of any sum shall normally be made out to the municipal.
West Bengal
West Bengal
Municipal Act
Municipal.
1990.
It is
I have. Section.
Section 69(2).
Yes.
No payment of any sum shall normally be made out of the municipal fund unless such expenditure is covered by any current budget grant and any sufficient balance of the such budget grant to available to of the purpose. Well, there is no budget. Well, he disbursed that amount also. See, well, kindly stop that, my lord, any future disbursement from the municipality
Very.
without budget pass.
That the Director Local Bodies will not do it till the time.
But that's why I prefer a writ petition.
Yes.
Well, I have entire allegation made before the respondent number 2 and 4.
Yes.
They, till date, no step has been taken by the respondent number 2 and 4.
Your lordship.
Yes.
It actually allows me. Well, only the main point well, that I have understood from the petition they have prayed for is the well, misappropriation of funds. Well, I have annexed all the audited balance sheet. Well, whatever the funds has been disbursed. The most interesting point is that, my lord, all the councillors, whoever taking this objection, they have not come with a single.
Forget the councillor, the Director Local
Yes.
Body himself is asking you.
Yes.
Well, we have already forwarded all the
No,
documents.
Lordship.
But these
There is
documents,
specific
I am filing before your lordship.
The instructions are there, sir.
Wait, I'll also, I'll also hand over a copy to my learned friend, if your lordship
What
directs.
is going on?
Whatever the documents I am having.
How,
But today,
how could you sanction anything without giving the budget approval and proposal to the director local body?
that is,
And
already.
how did the director local body sanction it, release the funds?
What has happened on 7th March, subject to correction, Lordship, as from the records what I could find, on 7th March, the budget has been accepted. Now, they are taking an objection beyond the period. Lordship knows as per section 82 of the Municipal Act, you have to take any objection if you want on the basis of within 2 weeks. All the councillors have filed on 30th March after 21 days. Now, the only point which flows from there.
That will not help you, sir.
They are taking only
Now,
the
this is before this court, that will not help.
Yes,
you. That argument is not going to help.
Very well. What I'll show before Lordship, I have already complied with all the balance sheet. I'm producing before the court, I have filed an affidavit to that
Kindly
effect,
see, after pending this writ application, when that budget had been recalled by the chairman itself. Kindly go through,
Recalled.
which was past forgery.
Mr.
Kindly see
No,
now.
You
I have not
file
been
your
sure.
reply. I will direct the director local body. See,
Yes.
Yes. I am filing the affidavit in
You file your reply too. Now we need to get this. You file your report by way of an affidavit. Report will do, Mr.
Yes,
Manju?
yes, ma'am.
Learned counsel for the respondent number 224. Now.
Yes.
2 and 4.
2 and 4. 2 and 4. 6 and is granted. 2 weeks, 3 weeks. How much time, madam?
3 weeks.
3 weeks time to file her report. Ms. Pyali Sen Gupta, learned counsel for the respondent number 2 and 4. 6 and is granted. 3 weeks time to file her report by way of an affidavit. Report by way of 6 and.
And in the meantime, there is
Exception to the
notice
same,
also
if any,
of the municipal
Within-
fund.
within 1 week thereafter.
Yes, ma'am.
Within 1 week thereafter. Full stop. Affidavit
Yes,
in opposition
Commissioner.
filed by the respondent number 5, right?
আমাকে দিয়ে
Yes,
দিন।
Respondent
Municipal Commission. Chairman of the municipal.
chairman, respondent number 5
I'm sorry, of course.
is taken on record. Learned counsel for the petitioner seeks and is granted
Soft copy, but at least.
2 weeks time to file his reply to the said affidavit in opposition. List after 4 weeks. In the meantime, I can't stay.
Only one
will-
thing,
That will not be.
today I should very candid before your lordship. Entire system in respect to the drainage system has been stalled because no fund is going to disperse in respect to the labors are concerned. So today in this rainy season, I can show you the photographs.
Sir, you do things in accordance with law.
I have whatever I
Follow
have,
the
I'm
procedure.
producing before your lordship. I'm
Follow
before
the
your lordship.
It doesn't reflect so from the statement of the director local bodies that you are following the process. We'll see that.
Wait,
Let the report of the director local bodies come, then we will see what exactly you have done and what process you have followed.
Opposition maybe,
Opposition, I'm taking on record.
Maybe sharp upon.
You have not served them.
We have not received them.
Give a copy to both of
I'm
them.
hearing.
Get
Excuse me.
Here and now I'm serving. If it can be recorded.
Mr. Mandal, whoever is the briefing council, give it to, yes.
Lordship, I have asked him to at least serve a soft
Give-
copy to me.
It's a huge copy. I'll stop.
At
You are
least
making huge money, but not giving huge document.
Totally contrary. I'll show you from the records. Only I have objected that the tender should be done in a very process of the
Huge-
department staffs.
Huge
That is the way
funds-
this person is to the heckle and
Huge
nothing
funds
else.
you have.
not
I'll
even
come
asking
back.
the hard copies. I
I'll come back with all the
supply
things.
the soft copy at least.
I'll come back.
I appear for the petitioner, my lord, in item 8. My lord may recall, this is that matter where the petitioner is requesting for issuance of a revised birth certificate.
I am appearing for respondent.
the corporation unit.
Yes.
My lord, on the last occasion, my lord had directed me to implead my father as respondent for, my lord. This has been done.
Yes.
My lord, the affidavit of service, I may be permitted, my lord, to hand up. My lord, I attempted, my lord, to...
Somebody appearing for the father?
Yeah, I am appearing for respondent number 3, the school, Techno India. I am not for the father.
My lord, I attempted to serve the respondent number for my father by way of special messenger as well as by way of speed post.
Yes.
However, my lord, he could not be located, my lord.
Could not be located.
Could not be located,
Then publication.
my lord.
Publication. You know what to do.
Of course, my lord.
Take steps.
I'll do that, my lord.
Take steps. Do it quickly so that we can dispose it off.
I'll do that, my lord.
Learned counsel for the petitioner seek some more time to serve upon the respondent. Four. Respondent number 4.
But I am appealing for the corporation only.
6 and is granted. How much time?
My lord, next
2 weeks time.
no, my lord, next Wednesday.
You'll be able to do it.
I'll be able to do it, my lord.
Publication.
Publication. I'll do it today itself, my lord, so that it can get published tomorrow.
6 and is granted further time to serve upon respondent number 4, the newly added respondent. Let this matter be listed. We'll have it 18th July.
My lord, I have no difficulty. 18th July.
18th July.
Grateful.
My lord, may it retain its position in the list. Grateful.
I'm grateful.
Grateful, yours.
You were somebody was supposed to file any replies to be filed in here. You can order the
No such order.
No such order.
Affidavit
No,
of
sir.
service, my lord.
Only the husband of the
18th.
grateful, yours.
My lord, item number 9 and 10.
As regard item number 10, my lord, in this matter, my lord, I am for the writ petitioner. My lord, I don't know, my lord, under whose instruction this matter has come up in the list, my lord. I never mentioned it, my lord, and no notice has been
My
served,
lord, upon the
how this matter has been tagged with this matter, but that I don't know.
my lord, may I interject, my lord?
It's all right. You have a problem in getting the matter heard.
Actually, my lord, but today I am not prepared, my lord.
So we'll have it some other day.
My lord, upon the
certainly.
on the last occasion, my lord, my learned senior for the state intimated that another writ petition,
Connected.
my lord,
So we'll have it on when Friday you want?
My lord, wait a minute, Monday.
Monday we'll have it.
Fine.
Not
I'm
today.
appealing for the state.
Monday.
But item number 11, my lord, this is an application for restoration
For the
application.
state,
my
my
lord.
lord.
11, my lord, Mr. Gautam Lahiri is appearing for the Srirampur municipality, my lord.
Yes.
He has not come to court, my lord, for the resolution, my lord. I'm paying for only 1 day accommodation, not 2 days.
My lord, then we
Friday.
keep on Monday. my lord.
Monday.
My mother has to be operated. My lord, so
Monday.
Keep reference.
keep-
Well, madam, I am for the petitioner, madam. This is my application for restoration of this, which was dismissed for default, my lord.
Mr. Das, any objection?
My lord, regarding restoration,
Restoration, no.
that can be done only one thing, my lord, may I submit?
Yes. Yes.
That is a petitioner. My lord, first, it should be restored first.
Let it be restored then.
Lordship.
The rest. For the reason stated in the application, the same is restored.
Lordship.
No objection on behalf of the respondent corporation.
I was opposing this application. My lord, heard us, extensively. Will that trade license matter? My brother was,
Who's there? Who's there?
nobody. Kindly, dismiss this because, today, the
But my application. Am I
Yes.
audible to
Ready.
you, Lord?
Yes.
Lord,
Mr.
Mr.
Karmakar
Banerjee
is
is
there.
always ready, Lord, to get my
Why you're not in
applications,
the
Lord,
court today?
Lord, this is an application. Lord,
Mr.
seeking,
Karmakar, why you're not here?
Lord, today,
You're in
Lord, there is some difficulty, Lord, I could not go, Lord.
All right. Yes, tell me.
Lord, this, Lord,
Mr. Kamoka, has got a new chamber, He is now fascinated with his new chamber, it
Lord,
seems.
Mr.
That's why you have
Banerjee
not
has
come into the
many
court.
more.
And
Lord,
did not throw a party, to anyone.
Lord,
Yes,
Lord,
Mr. Karmakar. Yes, tell me.
my, Lord, kindly takes my application for recalling.
Yes.
Your Lordship sees, Lord, page 14 is my Lord's order, of which, Lord, I have sought for recall. 2nd of April. Lord, this writ petition was filed, Lord, with a very innocuous prayer, Lord, seeking implementation of a previous order passed by this Honorable Court.
Yes.
Lord, I was not made a party in this proceeding. Although,
Yes.
Lord, I
No,
was
you were made a
partner
party in the proceeding. You were not made a party. Okay. Yes.
Now, Lord, although I was not made a party in the proceeding, after coming to know about this matter, Lord, I filed an application for addition of party.
Implement application was pending.
Yes.
You had filed, yes.
That is indicated in the order passed by your Lordship also.
Yes.
That's
I
indicated.
shall take your Lordship to Lord, that portion of
Yes,
the order
yes.
as well.
But nobody was there to move that application.
Yes,
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 sir.
Lord. The first day your Lordship took up this matter, Lord, I
Yes.
pressed this application. Lord,
Yes.
unfortunately, for some reason or the other, Lord, the matter could not be concluded. Your Lordship wanted the matter to be heard out on subsequent date. Lord,
Yes.
on 2nd of April, when this matter was called on, Lord, unfortunately, I missed the bus, Lord, I could not reach your Lordship. So that's why I could not press this application. And Lord, this order was obtained, Lord, although my application was served upon, Lord, all sides. Lord, this application was not indicated to your Lordship, and your Lordship kindly takes, Lord, the page 16 of my application.
Yes.
In the said submission, the present writ petition is disposed of by directing Principal such and such to, Lord, carry out the previous order.
Yes.
Since no affidavit such and such, Lord, your Lordship would, subject to correction, would not find, Lord, a single, Lord, observation, Lord, disposing of my application for addition of party, although that was appearing in the list.
Yes.
And Lord, your Lordship would find from page 14, it was appearing in the list also and the order also.
Yes.
But there is nothing, Lord, it was not indicated, perhaps, Lord, it skipped the mind of my Lord and also Mr. Banerjee, I'm sure. Now, Lord, my claim is, at the point of time when this 10th of May 2023 order was passed, at that point of time, Lord, I was a party in this proceeding and I was also a partner. The partnership firm was subsisting. Subsequent to this, Lord, order, my Lord, I had, Lord, dissolved this particular partnership firm. This partnership firm is out of at will. Lord, litigations are pending, arbitration proceedings are pending regarding, Lord, dissolution and accounts. Your Lordship, they have also made statement, I suppose, Lord, in the writ petition. Now, Lord, pending such proceeding and, Lord, without getting the, Lord, partnership dissolved in the manner the Partnership Act wants, Lord, the question before your Lordship is, Lord, today, whether municipality can grant a trade license in favor of a dissolved partnership firm.
Mr. Karmakar, if you see the order which has been passed on
My
which
Lord.
This order of 2nd of April,
my Lord,
the observation is in writ petition 313, that
My-
order needs to be implemented.
Yes.
If you see the order in writ petition number 313,
my Lord,
you can see that there is
Lord,
nothing.
that is exactly what I'm trying to impress upon your Lordship. Lord, when this 10th of May 2023
If you see
orders
page
was passed,
if you see page 53,
my Lord,
you will see the last paragraph: running business without valid license is absolutely illegal and improper. There is already an order passed by the learned civil judge restraining defendants so and so. Renewal of the trade license accordingly, the municipality is directed to take steps to issue the trade license in favor of the partnership. This
I'm
is
Lord, if this is the situation, then this is binding only in a case where the partnership form is existing. I and Lord, the petitioner before your lordship, rather the writ petitioner before your lordship, where Lord, the
Then
two
you should,
partners,
then you should have challenged that order.
Lord, there is no requirement for subject to correction. Lord, there is no requirement to challenge that. The reason is this order was passed at a point of time when the partnership form was existing. After this order was passed, situation has changed. There is no partnership form today because I have dissolved it. So, Lord, if there is no existence of a partnership firm, the question is, Lord, how can a Lord, license be renewed? Lord, situation could have been different. It would have been a company. There, Lord, I am a director, I am a shareholder. I go out, the company exists because it's a juristic entity. Partnership firms are unlike, Lord, such entities. Your Lordship knows much better than me. Lord, in a partnership firm, I cannot be forced to continue with the firm. Now, Lord, admittedly, father and two sons had started the business. Father died. The firm was continued by two brothers. Now, Lord, what I find from the writ petition is, conveniently, after Lord, this firm being dissolved, the writ petitioner's wife has been inducted as a partner, and the partnership firm has been shown to be a continuing partnership firm, which is Lord, unheard of and illegal also. Because until and unless the firm is dissolved, Lord, the compliance of Section 72 of the Partnership Act is mandatory. Lord, unless that is done, the partnership firm does not come to a.
Then you challenge the trade license on that basis.
Lord, my point before your lordship today is at a point of time when 10th of May 2023 order was passed. Lord, at that particular juncture, the existence of the firm was there. I did not dissolve the firm. Now, Lord, at that juncture, given those set of facts, this Honorable Court directed, yes, if the partnership firm is existing, why the license will not be renewed? Situation was completely different. Now, today, when I have dissolved the firm after that order, Lord, the question of renewing the license...
Have they acted upon it? The renewal has been done?
Not yet, Milord. Milord, there is a contempt application pending. Milord, this is a second attempt. Milord, I will make my submissions.
Milord, whatever the attempt is, Milord, this is what the law gives right to me. I am a partner.
Law
I'm
is
entitled
possibly,
to my
Milord,
share.
something else.
Yes.
The arbitration proceedings are on.
Yes.
The arbitration proceedings are with respect to Milord, dissolution and settlement of accounts. There, they did not disclose Milord, the new Milord, this deed of partnership that they have disclosed before your lordship. So, Milord, they are trying, this writ petitioner is trying to, Milord, conduct a fraud upon the arbitration proceeding and, Milord, trying to take away, Milord, some benefit from this Honorable Court without giving proper facts. Milord, kindly comes to their, Milord, the reconstitution, as they say, at page 62. Kindly comes to page 62. Milord, from the documents itself, Milord, I shall demonstrate, Milord, the manner in which things are being taken so lightly. Milord, kindly comes to page 63, the recital portion. And whereas by second paragraph, Milord.
Yes.
Rather first paragraph. Whereas by instrument such and such, 1980, executed Pareshnath, Amarnath and Gorachand. Amarnath is the writ petitioner, Gorachand is my client. And Pareshnath was the father. Now, Milord, that was started. And whereas further instrument dated 2010, executed Pareshnath, Amarnath, Gorachand, the terms of partnership got amended such and such. And whereas Pareshnath expired on 2017, the partnership business continued. Milord, the partnership permitted the business to operate in case of demise of a partner. So, Milord, we too started continuing with the partnership firm. Whereas partnership is permitted such and such, and whereas at the insistence of Gorachand Sadhuka, the business of Sadhuka was expanded by way of constitution, Sadhuka Enterprise such and such. And whereas after the death of Pareshnath, the said Gorachand and Amarnath arrived at an arrangement. Milord, this is completely unheard of. Arrangement in terms whereof it was decided by Amarnath and Gorachand Sadhuka that Amarnath would look after business of Joykali, Gorachand would look after business of Sadhukan Enterprises, the business of Sadhukan Medical would be looked after jointly. Now, this statement is, Milord, a complete perjury on the face of it. When I shall produce, Milord, the records of the arbitration proceeding, two matters. Shadu Khan Enterprises, separate arbitration proceeding is going on. Joykali Oil Mill, separate arbitration proceeding going on. Lord, if I produce the pleadings of the two arbitration proceedings, Lord, the fraud that has been played by this reconstitution deed will be apparent before your lordship. Lord, this is exactly what I want, why I wanted, Lord, myself to be added as a party, so that I could have demonstrated this before your lordship by way of an affidavit. Unfortunately, my lord, I was not there, my lord, I could not assist your lordship. Now, my lord, kindly turns over to page 64.
Yes.
Whereas in terms of the said agreement and understanding, Gorachand Shaduka has issued a notice of dissolution on such and such. So, my lord, admission 29th of June 2023. It's at will. So, my lord, immediately upon my notice, the firm gets dissolved. And the liability of section 72 arises. Section 72 has not been, Lord, for the time being, not been, Lord, implemented or applied. Lord, may I place section 72 once for your lordship's kind consideration before not placing this document further? Lord, Lord, may I request Mr. Banerjee, Lord, to give a copy of the Partnership Act to your lordship, Lord. I don't think this is a very, Lord, bad demand.
My client may hold me responsible for assisting you. Hey, Dada. But my lord is hearing, my lord, Mr. Komokar on merits of the case. My lord, whether he can open it up or not, my lord, that's the question today.
Only, Lord, that's the reason I'm not making my submission.
Let him make his submission.
Very well, my lord, sitting in a new chamber, my lord, is enthusiastic.
Lord, I'm only trying to impress upon your lordship, Lord, why your lordship should hear me on
You
merits.
should, Mr. Karmakar, this is an application for modification of the order. All that you are arguing is on the merit of the matter. Challenge this order.
Lord, this
In
order,
appeal.
Lord, my contention with your lordship today is, had it been the case that I would have assisted, I would have got a chance to assist your lordship, Lord, where my application for addition of party was pending. Lord, this order could not have been passed. That's why, my lord, recalling, because I was absent. Else, if I would have been heard, I would have filed a review, or my lord, I would have went for an appeal. That's a different context. It's only because my absence was there. So that's why I'm before your lordship, so that, Lord, considering the merit of my submission, if your lordship would kindly consider.
I'm trying to take my lord an instruction. My lord, I am not, my lord, shy of, my lord, facing his application for an addition of party. My lord, I have just, my lord, sought for an instruction. If, my lord, my client agrees to this, my lord, I will, my lord, invite him, my lord, to join in the writ petition and, my lord, to have it, my lord, thrashed out, my lord, once and for all. My lord, I'll just take instruction. Otherwise, my lord, I oppose this recalling application because, my lord, the amendments that have been made in the recalling application, it will put blame, my lord, on the court.
No.
It says,
But
my lord,
I shall place the recalling application also.
kindly, my lord, have a look at the amendments made in paragraphs 3 and 4. It says that, my lord, ought to have indicated a returnable date. Why my lord did not indicate a returnable date, which, my lord, make him, my lord, paralyzed. He could not, my lord, attend, my lord, the court hearing. Only because my lord did not indicate a returnable date, my lord, he could not be present. That's, my lord, how I'm sure, my lord, this is not drafted by Mr. Komokar. But blames are, my lord, put on, my lord, the
High court returnable dates are always there.
My lord, whenever, my lord, a matter appears in the list, my lord, that's a notice to the parties.
No, but in my court, returnable dates are always there.
My lord has seen, my lord, the statements made. And, my lord, the deponent says this is true to his knowledge. And he says that, my lord, my client has committed perjury.
This is always given in every
I'm sure, my lord, Mr. Komokar has not drafted
after 6 months, 8 months, 4 weeks, 6 weeks, 12 weeks. I don't do that.
This is always there. Lord, whenever I have, Lord, submitted with your lordship,
None of the cases in my court, dates are not given.
Lord, but
not
it's
even
returnable and on each returnable date, the matter appears. Lord,
Yes,
that
absolutely.
Lord, that appears.
Absolutely.
It goes without saying, my lord.
How can you make this statement? Neither any returnable date was fixed nor any order
It
was
says,
passed?
my lord called up the matter at 1:15 p.m. That was the first fault of the honorable court.
Yeah. Lord, this is not
My
a
lord ought
fault.
not to have
This
called,
is
my
not a
lord.
fault. Lord,
These are the statements.
Lord, this is not a fault, Lord, that has been indicated. Lord, this is not, that
You see
cannot
the
be a fault.
tenor
Lord,
of
court
the
can never
amendments.
be at fault. Lord, I understand Mr.
These are
Banerjee.
utterly disparaging remarks, my lord, made to the honorable court.
This
Mr.
is completely an argument on prejudice.
Mr. Karmakar, to put this, that the matter was called at 1:15, what are you trying to indicate?
Nothing. Lord, what I'm trying to say is I'll try next.
Why have you given this time of 1:15 p.m.?
Lord,
Mr.
I'll try and explain. Not the difficulty
The
is
very, this reflects the tenor of the draft itself reflects what you are trying to say.
Lord, absolutely not. May I try and explain to you, Lord? Lord, as I indicated while starting the submission, that Lord, on 28th of March, the first date of hearing,
Oh no,
Lord,
you
this matter
don't.
was taken up for
All
hearing.
right. You don't need to take any instruction, sir. You don't need to take any instruction. Mr. Karmakar, anything else?
Lord,
My client has otherwise been.
No,
Wait.
nothing.
Lord, may I try and explain? May I try and explain?
Take it in appeal.
Lord, may I try and explain? Lord, the only thing is, Lord, that on 28th of March,
This language and tenor of the application is not appreciated.
Lord, may I try and explain this?
No,
May I try
this
and
is an
explain?
application filed for review.
No, this is
My lord,
not a
one more thing.
application for
Kindly,
review,
my lord,
Lord.
have a look at the order. Kindly take me lord page 14. Kindly see, my lord, the application is also appearing at the head of the order. Can one is indicated.
Let him take it in appeal. All right. This is an application for review
No,
filed
this is
by
not an application for review, Lord.
filed by-
It's only an application for recall. It's not an
Recall.
application for review.
Review, recall, the same thing. Review of the
Lord, may I try and
filed by
explain to
the
your Lordship para 3?
filed by the Mr. Kamakar, I don't appreciate this. Filed by the review petitioner seeking reconsideration of the order dated 4/4/2025 passed by this court in the above captioned writ petition. Full stop. The case of the review petitioner is that he had filed Can 1 of 2025 in the said writ petition, comma, inter alia, praying for his impleadment as a party respondent. Full stop. It is his contention that this court, while disposing of the writ petition by the aforesaid order dated 4/4/2025, comma, failed to take note of the pendency of the said application for impleadment and as such, comma, the same remained indisposed of. It is pertinent to, this is your submission?
Lord, my submission is also, Lord, trying to explain the paragraph 3.
Only about the application. Facts I'm not getting into. It is pertinent to note that the writ petition was filed alleging non-compliance of the order dated 10/5/2025 passed in WP number which is that the order
That's indicated in my lord's order. My lord, I'll just-
WPA number 313
Yeah,
of
yes.
313 of 2023. Full stop. Upon consideration of the materials on record, comma, this court, comma, by its order dated 4/4/2025, comma, disposed of the writ petition with a direction to the respondent authorities to ensure compliance with the earlier direction passed by this court in WPA number 313 of 2023. Full stop.
My lord will also, my lord, kindly say that the scan 1 was indicated at the heading. So, my lord, the honorable
Wait,
court was conscious of.
wait,
my lord,
sir,
the
wait.
application.
No observation
Just
was
a
made.
minute, just a minute, just a minute, just a minute, just a minute. When the matter was taken up for hearing on 4/4/2025, comma, none appeared on behalf of the review petitioner, full stop. In the absence of representation, comma, this court proceeded to dispose of the writ petition, comma, along with Can 1 of 2025, full stop. It was the considered view of this court that the impleadment of the review petitioner would not serve any substantial purpose, comma, given that the writ petition was confined to securing compliance with an already existing and binding direction passed by this court in WPA number 313 of 2023. Full stop. It is well settled principle of law that the scope of review is extremely limited and may only be exercised where there exists a clear error apparent on the face of the record, comma, or where the order under review has caused manifest injustice, full stop. A review is not to be treated as an appeal in disguise, full stop. Upon due consideration of the grounds urged, this court finds no error or mistake on the face, on the mistake apparent on the face of the record, and would not warrant to exercise its review jurisdiction, full stop. Accordingly, the review application is dismissed. Full stop.
Well, since we have not used any affidavit to this
No
application,
affidavit.
all allegations are deemed to have been
No
denied.
affidavits have been exchanged.
All allegations are deemed to have been denied. My lord will kindly say that.
No affidavits have been exchanged. The allegations are deemed not to be admitted.
I'm so grateful. Grateful.
Get it remanded back, but don't use that kind of a language, Mr. Kar.
I'm sure, Milord,
Because
Mr.
this
Karmakar
language
I have
was
re-
not
I have
used the manner
restrained-
in which Mr. Banerjee had made
Mr.
some- made
Karmakar,
some-
it's
this
not
was
about,
not
no,
used in
it's
that way.
Mr. Karmakar, it's not about Mr. Banerjee. Please, you read the paragraphs. No, nobody indicates a time. Nobody makes these kind of statements.
That's
It's a
exactly
wrong
what I tried
statement.
to explain.
Mr. Karmakar, you are there. I'm not really putting it any further. But
I wanted
this
to
kind,
explain, Your Lordship,
this kind of
I
drafting-
understand. I understand that language is not happily drafted, but it was
not only
not
happily
meant for that.
drafted.
It
Mr.
was not-
Karmakar, I'm not making any observations regarding your drafting. I can go to the extent of actually saying that none of the cases in this court are not returnable with a date.
That I know.
This is the,
That
this
I
is the
know. That
practice.
goes without
It's a
saying.
wrong submission. On affidavit, you have made a submission. I can no wrong submissions on affidavit, Mr. Karmakar.
But it goes without saying, whatever is there, it goes without saying what is falling from your Lordship.
Not right
I
at all.
could have explained this, what has happened.
Grateful to your Lord.
You enjoy your new office. I don't want to burden you more.
I'm grateful.
Excellent office.
That's why I left him today.
Excellent office.
Otherwise, I would have wrong statement, Mr. Karmakar.
But there is a
First day, new office, you should enjoy it. I wish I would have allowed the application also, but it doesn't really.
This statement,
The statement is not right. Rest of the matters we'll take after lunch.
But I'm not feeling well. I'm having fever, so I'll go home. Lord, kindly. Item 14.
What is there in?
But tomorrow and day after I may not come
Leave
because
उसका होगा ना? हाँ, उसको डालो।
the very next matter, Lord. কোথায় গেল চক্রবর্তী? সোমবার কি মঙ্গলবার করে দিই? কবে? কি অর্ডার করাবে? আবার কেন অর্ডার? এর জন্য অর্ডার নট দিস উইক লেখা থাকে লিস্টে। আরে কালকে অর্ডার করতে ভুল নাম রেকর্ড করে দিয়েছে।
This is there. Content was
Lord, item 14, I am for the petitioner. Lord, it is coming after the affidavits. It will take some time, 15-20 minutes, Lord, it will take. So,
So
Lord,
we'll have it when you want.
next week, Lord, I am not well.
Anybody na
All of us are. Kindly just
From Monday, any date as well.
Tuesday?
Tuesday. Let us be only marked for Tuesday.
At the request of the parties, let this matter be listed on Tuesday.
ঠিক করে নাম দেন।
Mr. Chakravarti, what is your matter?
He is my adversary.
He
He is the private respondent. I am alleging illegal construction made by him. That's the thing.
And the CC is there.
All right,
Yes, please.
Tuesday.
ঠিক করে নাম দাও, ভুল রেকর্ডিং না হয়।
হ্যাঁ দিচ্ছি
My lord, in this matter, I am for the petition.
I'm for the state respondent.
My lord, the factual matrix of this case is, my lord, the private respondent constructing a G+4 construction just opposite to the petitioner's plot, my lord. The petitioner, through an RTI report, came to know that the sanction was only granted for G+1. It became so clear that all the floors which are made above G+1 are completely illegal and unauthorized, my lord.
Sanction was for G+1.
G+1, my lord.
And 3 extra floors.
We have given a show cause, we have heard them. Already police has been instructed to give us police force so that we can demolish it.
Demolition order has been passed.
Already, my lord, I am placing the police report itself.
Then what is left?
Nothing served upon us, actually.
Police, we cannot serve them.
At least self-demolition notice.
There's a work stop notice.
My lord, thereafter police has been instructed.
But what about the demolition notice?
I will come with the demolition.
Come with
the lordship fixes on next week, I will give them.
Take down the petitioner. The petitioner, preferred the present writ petition, alleging inaction on part of the respondent authority in failing to take any action against the alleged unauthorized construction at premises number 58/6 Naskar Para Lane, PSAJC Bose Botanical Garden, Havra, at the instance of the private respondents. Full stop. It is the case of the petitioner that he is, you are at the adjacent house?
Opposite plot holder, my lord.
That he is the resident of 53/6, same Naskar Para Lane, so and so, full stop. In his neighboring plot, the respondents in his neighboring area, the respondents are carrying out unauthorized construction in deviation of the valid sanction plan. Which is for G+1 floor, 1-story building. But the petitioner alleges that the private respondents are constructing G+4-story building, further encroaching upon the common passage. Full stop. Learned counsel for the petitioner states that he has made several representations before the respondent authority, but the respondents have failed to act upon it. Full stop. Learned counsel for the respondent, Havra Municipal Corporation, Mr. Sandeepan Banerjee, appears and states that
hearing has been already concluded on 14 May.
That notice under section 177(1) of the HMC Act 1980 has already been served upon the alleged private respondent against the private respondents. Full stop. He seeks and is granted further time of 2 weeks, 3 weeks, Mr. Banerjee. Banerjee, how much time?
Hearing. 2 weeks.
2 weeks time to file his report by way of an affidavit.
Then 3 weeks.
3 weeks. Report by way of an affidavit indicating the steps taken in furtherance of the illegal and unauthorized construction. Alleged illegal and unauthorized construction. You are for some private,
For the private respondent number 8 to 17.
yes,
My lord, private respondent number 18 is the, my lord, developer. We are the landowner, my lord. We have given our property for the for a new construction, my lord. It was his part of the part of performance that he will get the sanction plan and he will develop the property in accordance to the sanction plan, my lord. Now after that, my lord, he have already raised G+4 sanction plan, my lord, even as the possession. Handing over the possession, he left, my lord. Even he is also the party in respect of in this writ petition, my lord. He has been served, but he is no way appearing, no way contacting with us, my lord.
do you have the sanction building plan?
Pardon, my lord, I do not have the sanction building plan.
G+1, they have admitted.
G+1, my lord. I do not have the sanction building plan for G+4, my lord.
Very good.
And
But
they have
that is
admitted
the-
in the hearing.
This is the
Learned
actual
counsel for
story,
the
my lord.
private respondent admits that he has a sanction building plan for G+1 floor, but in contravention of the said sanction plan, full stop. He states that he had entered into a.
Pardon, my lord.
You had entered into agreement.
I went with a development for development agreement
He
with the
states that he had entered into a builder development agreement with respond number
18, my lord, the last respondent.
And
respond
also
number
power of attorney is also there, madam.
Development power
18.
was there.
18. Yes, building development with respond number 18. He further states that the builder, i.e. respond number 18, was supposed to get all the requisite sanction plan for construction of the additional floors. Full stop. He fairly concedes that the builder, that the builder, i.e. respond number 18, had not got any sanction plan and the construction has been raised without any, and the additional floors have been raised without any sanction plan. Full stop. We want to file
We
something?
subsequently, my lord, get acquainted with the fact when the writ petition was filed, my lord. Before that, when we have asked for the sanction plan and all other documents, my lord, the developer never produced a sanction plan before us.
That's your problem.
Yes.
My lord, I agree, my lord, but that is
Let
the, my
this-
lord, matter of
this
fact.
matter will be listed after 4 weeks. 6th August.
Great.
6th August.
Grateful.
Grateful, man.
Huh?
Minute I am for the
Well,
petitioner.
Lordship directed to submit a report. Report has not come. I was expecting, but the information which I received, but I ascertained from my learned friend Parasma that instruction is not wrong. Over phone, what instruction was given might be, my lord, he is mistaking about the premises numbers. But your Lordship kind of gives me another time because I have ascertained what my learned friend is contending.
Learned
It is a
counsel.
demolition order. In fact, my lord, short issue because the demolition order has already been passed. He has come to this court for implementation of that order. Therefore, my lord, it has to be implemented. There is no difficulty in it. It is to be executed by the department, provided there is no appeal by the person responsible before the tribunal. Possibly in the meantime, no communication has been received by us. Therefore, it has to be executed. And we last asked for a report that what is the progress or what is the program of execution of the order of the special officer building. Well, this is the position.
Learned counsel for the respondent, Calcutta Municipal Corporation, Mr. Alok Ghosh seeks further time of 2 weeks. Further time of 2 weeks to file his report in terms of the order dated 4/10/2024. You want to file your exception to that report? Should I-
Yes, madam.
Exception, if any, to the said report within 1 week thereafter. 1 week thereafter, list after 6.
Next August. I'll come.
Item number 79 for the petitioner.
My lord, appearing on behalf of Kolkata Municipal Corporation, my lord.
There is a affidavit of service. Affidavit service and the short written notes. Kindly peruse the short written notes. The private respondent number 9 constructed illegal G+2 building with third floor RCC building columns at premises number 1A Atulsur Road, PS Tangra, Kolkata 70015 without a building sanction plan to Kolkata Municipal Corporation. The illegal G+2 building encroached upon the nearest premises without leaving slight front open space on side 1, open space on side 2, rears open space as prescribed under Rule 62 of the Kolkata Municipal Building Rules 1990. Thereby infringe fundamental rights and easement rights to natural air, sunlight and air for the residents in the locality. The illegal building built with poor quality building materials, most likely to sudden collapse anytime, cause electrical fire hazards in the building and adjacent buildings and locality and possible lives of the residents in the locality. The illegal building caused choking of the drainage supply, water supply in the area. The illegal G+2 building forbidden by law, fraudulent, involves injury to the residents and the building property of the residents, and opposed to public policy. Just last para. Reliance is placed upon the Supreme Court.
Where? Never argue like this. Not supposed to argue like this. They've handed over notes, good. But at the same time, don't read it out like this. When will you develop your argument skills if you read it like this?
I have summarized all my arguments in this
You have
one page.
summarized your argument, very good. But you're not supposed to read out like this. You're supposed to advance your arguments. All right.
No.
But I have already issued notice for stop work, my lord, under section 401 of the KMC Act, and already prepared the demolition sketch and all forwarded it to the superior authority under section 400 of KMC. And anytime demolition order may be passed by the higher authority, my lord.
Yes. Your private
I
respondent.
am for the private respondent number 50.
Yes. Respondent number 9. Yes.
Now,
Gopal Das.
Lordship, first of all, Lordship, absolutely it's a fact that as on today, Lordship, there is no sanction plan. But for this reason, Lordship, the respondent number 9 is not at all responsible. Why? Because a development agreement was executed between me and other co-owners.
Did you hear the last matter?
Lordship.
You were here, the last matter which was taken up by this court.
I'm sorry, sir.
You were not paying attention. Same facts.
That developer, Lordship, constructed the building. Now, Lordship, as on today, when I got the notice and at the inspection, I said that there is no sanction plan. But Lordship, my submission kindly be recorded that petitioner entered into a development agreement, promoter has developed. Promoter is not a party in the writ petition. Another thing is, the conduct of the petitioner is also not tenable. Lordship, this petitioner is a tenant in respect of a portion of a flat. Now, Lordship, the tenant has been evicted. This tenant has
No. I'm very much in
Just
the
a minute. Let him make his submission. Yes.
The tenant has been evicted. Now, tenant has filed an application before the consumer forum for restoration of the flat, concerned flat.
Before consumer forum?
Before the consumer court. Now, Lordship, in one hand, tenant is trying to get the possession of the tenant rented portion. And in the other hand, when he fails, he filed this for demolition of the building. Now, Lordship, this is the crux issue. But
no, I have not failed. It is still pending.
And it has not been disclosed.
No.
Just a minute. He's making his submission. You have made your submission. He's making his submission. Wait. Learn to wait. Yes.
Now, Lordship, it has not been disclosed in the writ petition also that I had see that this she has filed an application before the consumer forum. Now, Lordship, kindly see the prayer of the consumer before the consumer forum. I'm just reading, Lordship. To give delivery of the peaceful vacant possession of the settled property as given in the schedule below in habitable condition as per the condition of the agreement of lease dated 8 September 2012 to execute registered the deed of lease in respect of the properties as mentioned in the schedule below according to the terms of the agreement of lease in favor of the complainants. Absolutely, Lordship, this writ petition, Lordship,
I
whereas
hope you are not advising the tenant. I hope you are not advising your client for consumer court.
I'm not getting.
আপনি কি অ্যাডভাইস করেছিলেন যে যাওয়ার জন্য ওখানে ক্লায়েন্টকে?
না, আমি advice করি।
Very good.
Now, Lordship, this is, but Lordship, more or less, Lordship, it is admitted fact that there is no sanction.
Now
Yes.
yes, I place my reliance upon the Supreme Court of India judgment, where it is clearly mentioned, no matter how many years has elapsed, illegal buildings should be demolished. And for this, I place my reliance on 2024 SEC Online
Hey,
SC
right, sir, I know
3767.
what you're saying. Where do you stay now?
Alipur.
Where is the property?
Tengra.
In Tengra,
How far?
maybe about 5-10 kilometers.
What is the interest? What interest do you have in this property?
No, I am very much resident in the property. I'm petitioner is a resident in the property.
In this property, you're
Yes, he's a resident. Yes, petitioner is a resident.
as of today, you're staying.
Yes, of today.
You have not been evicted from the property.
Means I have been evicted by some illegal activity, from illegal force, by
Are you
force.
staying or not staying is the question which is being put to you. Are you staying in the property today?
I am not staying there right now. I have been illegally evicted from the property, number one. Later on, I came to know the building has been, that this is an illegal building and without constructed without building sanction plan. So I want a new building.
Take down. You want a new building?
I want a new building to be constructed. In terms of Supreme Court India, which is clearly states,
Supreme Court India.
no, Supreme Court India's judgment is clearly stated that any illegal building, no matter how many years has elapsed, should be demolished. And that is a 2024 SEC Online SC 3767 that Supreme Court has given the direction to the High Courts.
How long you have been in practice?
More than 8 years.
More than 8 years. Very good. Who was your senior?
Pardon?
Who was your senior?
I have no senior.
Never had a senior.
Never had a senior.
Shows, reflects. The petitioner in the present writ petition challenges the petitioner has filed the present writ petition being aggrieved by the inaction. Where's the representation you have made?
I wish. Page number
22.
Page 22. And the photographs is page number 20. Annexer P1. Page 20.
Is aggrieved by the inaction of the respondent authorities in not taking any action for demolition of the alleged unauthorized construction at premises number A1 Atulsur Road, PS Tangra, Ward number 58, Calcutta. Comma, by the private respondents. Who are the ones who have, how many private respondents?
9, only one.
By private respondents. By private respondent. Only one is by the private respondent. Full stop. Petitioner states that she was one of the tenants in the above mentioned property. Full stop. She was evicted from the said property. Have you stated so here?
I have, I didn't receive the instruction before. I heard there some other lawyers conducting the case, so I have no had the.
The petitioner has nowhere stated that she was a tenant in the above mentioned property in the writ petition. The petitioner has not even stated that she had been evicted from the said property. The petitioner has filed a, give it to me, sir. The petitioner has filed a case.
Consumer.
The petitioner has filed a case before the Consumer Dispute Redressal Commission. Complaint case number 106 of 2024. Wherein she has sought where she has sought a temporary injunction restraining the respondent number 9 herein and his men and agents from transferring possession or handing over possession of the scheduled property to any third party in any manner, and will pass an injunction order with an ad interim relief in terms of the prayer for restoring the petitioner in the above mentioned property. This is what he has asked. Full stop. Currently, learned, when the court has put a question to the petitioner that how he is connected to the present property and why he has not disclosed the said facts in the writ petition, the petitioner is unable to satisfy this court to the extent that
this court has a distinct jurisdiction. Here is a writ.
Can you keep quiet? Extent that the petitioner today is living at, give the address, where are you staying?
And the short written notes first line. 1A Atulsur Road, PS Tangra, Kolkata 715.
Where are you staying today? Where are you staying?
I'm staying in the cost title.
At 1 Kapuli Bagan Lane. This is in Alipur.
1 Kapuli Bagan Lane, PS Intel. Nearby.
How far is it? How far is it from the property?
2-3 kilometers above.
How come you said you are living in Alipur?
I'm not following.
Just now you said you are living in Alipur.
No, I am staying in Alipur. I thought you asked me. The petitioner is staying. That's why I got confused.
In 8 years, you don't know what is the difference between.
Merely a few kilometers.
Is staying at 1 Kapuli Bagan Lane, PS Entally, Calcutta. Full stop. Though the petitioner has not come to this court with clean hands and has suppressed.
May I be given the liberty to file this by way of supplementary affidavit?
Do you withdraw this, file another petition?
I'll withdraw this. I'll file the writ petition fresh.
Learned counsel petitioner seeks to withdraw the present writ petition
With liberty to file it.
with liberty to file appropriate proceedings in accordance with law. You were practicing here in
I'm
Calcutta
practicing.
High Court?
Calcutta.
You done?
Deeply grateful.
Grateful.
And why you chose not to have a senior?
Why you choose not to
Yes.
have a senior?
Yes.
Why you choose not to?
You didn't feel that?
No senior wills to keep me, so I.
That's the problem.
So I read my own books, I read jurisdictions and Article 226
Very
and
good.
reference books, and I move ahead.
Very good.
Deeply
Grateful,
grateful.
Lordship. Grateful, Lordship.
At 18, my lord, I appear on behalf of the Kolkata Municipal Corporation, and I'm being led by Mr. Vishwajit Mukherjee in this matter. This matter came up.
Mukherjee, you know what it is? What is there in this matter? Nobody is here for the petition.
No, on the last occasion, my lord, we were placing the 2023 SCC online page 663, paragraph 153. 143.
Nobody appears today also.
Yes,
Last
sir.
time also nobody had appeared, but today we have no adverse order.
Same, man. Why keep it on Monday when Mr. Mukherjee has got some health issue? Yeah.
Monday.
This was in respect of as is where is and what is where is basis Mr. Mukherjee.
Oh, that judgment also
Yes,
which he has, yes.
I keep it on Monday, man.
That division bench judgment.
Yes, yes. Division bench
And the Supreme Court.
Supreme Court 2023 SCC online 663 paragraph 143 and 146. I'm grateful, man. We'll come back on Monday.
None appears for the petition. Just record that. None appears for the petition. Today also there is no appearance on behalf of the petitioner. Even on the earlier occasion when the matter was listed on such and such date, there was no appearance on behalf of the petitioner. Let this matter be listed on Monday. Okay. Today also. Such and such. There was no appearance on behalf of the petitioner. Let this matter be listed.
I'm obliged.
My lord, I am appearing on behalf of the Bali municipality, my lord.
My lord, I am appearing on behalf of the private respondent.
The respondent, corporation, all are here, petitioner is not.
Yes, my lord, we have challenged our notice for demolition, my lord. The demolition order has been passed and
tested in appeal and affirmed, my lord. The demolition order has been tested in the statutory appeal, affirmed. They are facing contempt now, my lord. So
This was listed the other day also.
yes, my lord, yesterday. They are avoiding it, my lord. They have good reasons to avoid it, but because citing the pendency of this,
But
they are
today,
seeking.
today no adverse orders.
I understand.
None appears for
my lord, this is the third occasion this matter is appearing and they are not there.
what to do.
Yes.
Today we can't pass any adverse orders.
Yes.
None appears for the petitioner. In the interest of justice, adverse orders are deferred.
If your lordship can.
Let this matter
Day
be
after
listed.
tomorrow, tomorrow I have some different.
Friday? Friday?
My lord, my lord.
No one came.
State, my lord. My lord, I beg to appear on behalf of the respondent number 7 and 8. The order of the demolition which was passed, the writ petition has been filed that the order of demolition is bad, but that order has been challenged before the civil court.
None appears for the petitioner. In the interest
My
of
lord, I am appearing for the Uttarpada Kotrang municipality, my lord.
give your appearance, sir.
My lord.
Mr.
My lord, and
Shah,
I tender apology, my lord. From next time in the future, my lord, it will not happen.
Yes, this court doesn't forget faces.
My lord,
Remember
my
that.
lord, my lord. First and last, my lord.
Yes.
My lord. Deeply obliged, my lord. Deeply obliged.
You have to do. None appears for the petition. In the interest of justice, adverse orders are deferred. List on Friday.
Deeply obliged, my lord.
11 তারিখ না 12 তারিখ 9 11
I see mostly respondents now. Mr. Ghosh is here. Mr. Banerjee is here.
কি দিচ্ছে
I am appearing, Lordship.
ওই যে নিখিল গুপ্তা না 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 না, আমি 7
For that municipality is Nikhil Gupta. Yes, sir.
This writ petition I have filed, Lordship, challenging the demolition order passed by Howrah Municipal Corporation dated 1st October 2024. But during the pendency of the writ petition, Lordship,
Yes.
Howrah Municipal Corporation has demolished the building.
Then nothing survives.
I have to take instructions regarding that.
Mr. Banerjee,
Because he has challenged the demolition order.
এই যে 7 8
If you have challenged the demolition order, you want to pursue it, then I'll hear it, I'll uphold the demolition order or dismiss the demolition order, depending on what are the facts.
Building has been demolished, Lordship.
So withdraw it. If your building has been
Let them
demolished,
withdraw it.
why this has become infructuous, sir? You know it has become infructuous.
Lordship, kindly record my submission that the building has been demolished, so I am with.
All right. Learned counsel, the petitioner states that the building has already been demolished and the present writ petition has become infructuous in view of the said development. Learned counsel, the petitioner seeks to withdraw the present writ petition. Writ is dismissed as withdrawn.
Dismissed as withdrawn.
My lord, on behalf of Mr. Suchit Kumar Banerjee, learned counsel, your lordship. My lord, he didn't come to court today. My lord, kindly fix it up on Friday. He will come. Due to his illness, he could not come.
Proxy counsel so and so appears and states that the main arguing counsel, Mr. Sujit Kumar Banerjee, is indisposed. He prays for a short adjournment. Let this matter be listed. Mr. Ghosh, when do you want? Next Tuesday.
Next Tuesday.
Give your appearance, sir.
Yes, watch.
One line order helps.
Today is not to pass any adverse order resolution.
No, but does the one line order help you?
Yes, my lord, obviously, I am waiting.
None for the petitioner. In the interest of justice, adverse orders are deferred. Let this matter be listed. When do you want?
Any day. Friday or Monday.
Monday.
Okay.
I don't see anybody else. I see your juniors. I see his juniors.
Today, I think, my lord, no one is now appearing today. Naki phaka hoye geche.
You are in which matter? Respondent.
So respondents are
Petitioner, which matter? All right. Call out the other matter. Call out the other matters 24. The same order, huh? None appears for the petitioner. In the interest of justice, adverse orders are deferred. List on Tuesday, Mr. Ghosh, same. Tuesday. 25.
I am for the respondent, madam.
Kamal, same order. Huh? None appears for the petitioner. In the interest of justice, adverse orders are deferred. List on. When do you want?
Tuesday, madam.
Tuesday.
25. It is Tuesday or later? Friday,
No, it is Monday.
Monday. That 26.
Here I am for the Kolkata Municipal Corporation, madam.
Yes. You are there in 26, sir? Or same, none for the petitioner.
Tuesday.
Yes.
Sorry, sir. On private respondents. On 27, I am for the respondent number 9.
27, I am for the municipal dealers. But this is the affidavit service. And the petitioners and the private respondents are all siblings.
In item number 21 was I was just coming.
Sorry, sir, it has already been called out. No adverse orders are passed. What is the?
I am coming on leave to Malad is missing.
No problem. Oh, give your appearance. In 21, put it up.
The petitioners and the private respondents in this
Yes.
matter are all siblings, and they are all the co-owners of a property, undivided property. Now, my lord kindly comes to page 26. In 2014, the Rajpur municipality has already declared this building is unauthorized, but till today, no steps have been taken. Page number 26. This is letter of the councillor. My lord,
Yeah, decide his representation.
Yes, madam. Yes.
Mr.
Lordship.
What is your name? Sorry.
It's been 12 years, my lord.
Mir Onuruddha, my lords.
Mr. Anirudh, decide his representation. You are appearing for the Rajpur Sonarpur.
Lords.
But it's been 12 years, my lord. They have not done anything, your lordship.
What do you want?
Demolish.
Why demolish?
Let them take a decision. If it is illegal, they will demolish.
Brother, sister, fighting for nothing.
But in view of the page 26,
You are what? You are state.
Oh,
You have
no,
nothing.
I am the private respondent. I am siblings.
Oh, you are the private respondent.
Yes, my lord.
Why do you fight with your brother?
No, that is an undisputed thing that is an illegal construction. Now, my lord, the issue is if
The
that
more
is an
you,
illegal.
the more you speak, the more you attract.
But that's what I'm saying, my lord. Let them construct. Let them take a decision on the representations.
You don't speak.
My
It's
lord.
better for you.
My lord.
Yes, why you have not taken any action till date? It is admittedly an unauthorized construction, sir.
26.
Lordship. That observation of the
Page
council-
26, sir. See the.
Lordship, this is the councillor, Lordship.
Yes.
In 2014, Lordship.
If your counselor is saying it is unauthorized,
Lordship.
why you have not
That has
taken
not
any
been placed
action?
before the board of councillors.
And it is-
Kindly 2024, comes to page 43. I have the
2014,
Lordship.
Till date, you have not even decided his representation. Dated 14/11/24.
2024 matter, or 2014 matter.
Plus page 40 and 41 is also representations which are yet to be considered since 2014, 2023, 2024.
And 43 is the photos of this unauthorized part.
Any photograph of the unauthorized?
Page number 43. This upper portion, it's unauthorized.
Why you don't put colored pictures?
I bow down, my lord.
For the court file, there should be a colored picture.
Sure. Well, I apologize for.
Yes, you'll decide his representation. The petitioner has preferred the present writ petition. Is the petitioner in the present writ petition is aggrieved by the inaction of the respondent authority in not taking any action against the alleged illegal and unauthorized construction being carried out at jail number 44, Khaitan number 648, Dag number 251, Mauza, Tetul Beria, PS Narendrapur, District South, 24 Parganas, at the instance of private respondents 7 to 11.
7 to 12. 7 to 12.
7 to 12. Full stop. It is the case of the petitioner that he is the co-sharer, co-owner of the above mentioned property with the co-sharer of the above mentioned property with the private respondents. Full stop. It is his allegation that the private respondents have carried out unauthorized construction in the form of an additional floor on the existing structure without his consent and without obtaining the necessary permission from the respondent municipality. Being aggrieved by the same, the petitioner has preferred the present writ petition. Full stop. Learned counsel for the respondent submits that they are ready and willing to decide petitioner's representation dated.
Lordship, this is the complaint with regard to the tenant has
Whatever it is, you decide the representation. You just have to see whether the construction is legal.
The direction will be again upon the owner, Lordship. Tenant, there is no provision in the section 218, Lordship. Owner will remove the unauthorized construction.
Whatever it is. You are not bothered about the tenant or the owner. You are only bothered with the unauthorized construction.
14, 11, 2024.
Representation dated.
Lordship, 11, no. 123.
24. 14, 11, 24.
24.
So representation page 37.
Lordship, last representation is 11th, 123 as page 31.
Those are reminders. Page
31.
Officer in charge.
No, 31.
31 is to the police.
No, that's a police one. Page, sir, page 37. Who's briefing
37,
you?
Lordship.
Madam, what are you briefing him?
37, Lordship.
Representation dated 14/11/2024. Full stop. Learned counsel the petitioner states that he shall be satisfied if the same is decided within a time-bound manner. Full stop. Learned counsel for the respondent, private respondent, also states that is there any civil dispute pending?
No.
Nothing. Then don't. Nothing for the private respondent. In view of this court directs, in view of the submissions made by the learned counsel for the parties, this court directs respondent number. Your respondent number?
9.
Not you. Who will decide, sir? The assistant engineer?
Lordship, assistant.
4.
4. The executive engineer. Respondent number 4 to decide.
No, there is no executive engineer in this municipality, Lordship.
Then how has
Lordship, 3, chairman.
The chairman. Respondent number 3, the chairman. Rajpur Sonarpur municipality to decide petitioner's representation dated so and so within a period of 8 weeks. Within a period of 8 weeks from the date of communication of this order in accordance with law. सब में comma कर देना, comma in accordance with law, comma after affording an opportunity of personal hearing to the petitioner as well as the private respondents, comma by way of a speaking order. Full stop. With the above direction, the present writ petition is dismissed.
Lordship, kindly add an interested parties. Their tenant has there an interested party.
Private respondent or any other stakeholder.
Gratefully, Lordship. Gratefully.
May I please your lordship,
Lord,
my
I
lord.
beg to appear for respondent 4, 5, and 6.
I'm appearing on behalf of the state, your
My
lordship.
lord,
For the municipality, my lord, I am
My lord, I beg to appear for the petitioner in this matter.
Yes,
my lord.
sir.
My lord, there are three petitioners before your lordships, my lord.
Yes.
That they are brothers and sisters in relation, my lord. Petitioner 2 and 3 are sisters, my lord. Petitioner 1 is their younger brother, my lord.
Yes.
My lord, paragraph 2, my lord, will show, my lord, that they had a plot of land which their father during his lifetime purchased.
Yes.
It's measuring around 8.4 decimal, my lord, and the description is given in paragraph 2, my lord. My lord, the father of the petitioners died intestate, my lord. The father was survived by the petitioners and another son, my lord. So there were 2 brothers and 2 sisters, my lord. Out of them, 3 are before your
And
lord.
his father's brother.
No. Father has 4 sons, so 4 children, my lord. 3 children are before your lordships. 1 is not there, my lord.
Why one is not there?
My lord, he is no more in the world, my lord.
He has legal heirs.
His legal heirs are there, my lord, but they will not be of, my lord, they are not necessary parties, my lord. My lord, what happened? The other brother, my lord, during his lifetime, my lord,
Yes.
donated or sold, my lord, his part of undivided share in the father's property, my lord, to the municipality. That your lordship will be pleased to find, my lord,
Yes.
at page 33. 41 is in English, my lord, a letter which will make, my lord, things.
Page
41, if your lordships kindly have, my lord.
Yes.
So, my lord, this is a letter which show, my lord, that there is a registration of a deed, my lord. And my lord, this land, if your lordship sees the quantity of land given at the last particular of land, my lord, in that column, the last line is the quantity of land, my lord.
Yes.
2.1 decimal. So, my lord, 8.4 was the total. 4 heirs were there, my lord. So 2.1 decimal each were their allocations, my lord. Though it was undivided, but he sold undivided portion of 2.1 decimal to the municipality. This was done, my lord, in 2018, as it would appear, my lord, in the letter on the head itself, my lord.
Yes.
Now, my lord, after this, my lord, my lord, left, my lord. The father died. I'm sorry, my lord. Father died on 10th of March 1999, my lord. And this gift or sale deed was executed in 2018, my lord. And the brother, my lord, he left for the abode, my lord, on 4th of October 2020, my lord, after 2 years of execution of this particular deed, my lord.
What is these are civil disputes. Why are you raising it here?
There's a civil dispute
Well,
also.
if I may just indicate, my lord.
Yes.
But thereafter, what happened, my lord? The municipal chairman, my lord, under the garb of this particular deed, my lord, which was the undivided property, took away the whole land, 8.4 decimal land, and they have constructed, my lord, on the whole 8.4 decimal land, my lord. Now, my lord, I give a representation to them, my lord. They don't consider, my lord. I file a civil suit, my lord.
Very good.
Civil suit, they don't appear, they carry on with the construction, my lord. The civil suit was carried on, my lord, ex parte, my lord. Civil suit has been heard 1 year back. No order has been passed, my lord, in the civil suit, my lord, till date, my lord. My specific instruction, my lord. They have not entered appearance also. They carried out with the construction, my lord, on whole 8.4 decimal. I made multiple representation. The chairman, my lord, since he belongs to the political dispensation of the state, my lord. He thinks himself to be above law. He don't think himself. He don't think, my lord, he is required to go before a court of law to present his case also, my lord. The civil suit is still today pending, my lord. Argument has been advanced, but no order has been passed, my lord, for last 1 year, my lord. That is pending. Civil suit was filed, my lord, in the year 2021. We are in 2025, my lord. This is where, my lord.
Do I need to tell you what you need to do when you file a civil suit?
No, my lord, that is
If
there.
they are not there,
my
is
lord,
the court
my lord,
can't pass orders?
it is not passing, my lord. That's what my specific instruction, my
So,
lord.
sir, if it is not passing, you should know what to do.
Yes, my lord, that I
Not
know.
writ petition. Do
That
you
is-
file writ petition for civil disputes?
That is one part of it, my lord. My lord, just because I have filed a civil suit does not takes away my fundamental right under Article 300A of the Constitution of India, my lord. My lord, they have not entered also appearance. I have filed a civil suit in 2021, irrespective of the civil suit. They continue, my lord, the construction with all 8.4 decimal, my lord, where admittedly they have only purchased undivided portion of 2.1 decimal in the whole property, my lord. It's an admitted position, my lord.
The moment you use the word undivided portion,
My lord.
That's where the problem starts. There's no demarcation, sir.
Yes, my lord. So they ought to have.
So in writ court, I will demarcate the property.
Yes. They have already taken away the property, my lord. I am only seeking today before your lordship is that, my lord, if they want to take.
Make your submissions.
My lord, since they have taken away my all property, my lord, without any consent, without due process of law, my lord, all I am beseeching before your lordships today, my lord, authorities may be directed to, my lord, take steps in accordance with law, my lord, to provide me compensation for the property that they have already taken away from me, my lord.
Compensation?
Yes.
Is this the forum for compensation? Where is the relief sought for compensation?
My lord, kindly have my prayers, my lord. My lord, kindly have prayer. Yes, lordship.
A is for return.
Compensation for taking over your property?
My lord.
Very nice. All right. Yes.
My lord, forcefully, my lord.
What else?
My lord, illegally and forcefully they have taken away my property, my lord. They have today they are equipped with all the photographs to demonstrate before your lordship that all construction have already been done in the property, my lord. Notwithstanding a civil suit, they chose not to appear in the civil suit, my lord. For last 3 years, my lord, the civil suit is pending, my lord.
Yes.
My lord, they have taken away, my lord, my ancestral property, my lord, in a society which is supposed to be governed by a rule of law, my lord. My lord, if they required that land, they could have very well taken it in accordance with law, my lord. Nothing could have prevented them, my lord.
Yes. Anything else?
My lord, those are my exclusive submission.
Yes.
I've already submitted before your lordship that there is a civil suit which is pending, and this has not, as my learned friend has also submitted, that nobody has.
Therefore,
I'm appearing for the municipality.
Yes.
My learned friend's allegation is that, my lord, municipality is not representing, my lord. My lord, the plot of land which is claimed by the petitioner is, my lord, situated at, my lord, LR plot number 26, my lord. Total land, my lord, comprises, my lord, 86 decimal, my lord. And the petitioners, my lord, claiming to be the owner of, my lord, only 6.4 decimal, my lord.
Yes.
The municipality, my lord, constructed crematorium, my lord, for my lord, Sosan, my lord, for solid waste management, my lord. But that is not in their land, my lord. Out of, my lord, 4 co-sharer, my lord, one sold out to the municipality. One of the petitioner, petition number 3, my lord, already received 1 lakhs from the municipality, my lord. And, my lord, my third, my lord, prayer is that, my lord, a civil suit is, partition suit is pending before the, my lord, the civil court, my lord. And in the writ petition, my lord, they have prayed for 2 fold of, my lord, prayer, my lord. First, my lord, to return the plot of land. And secondly, my lord, to pay the compensation, my lord. Prayer B for compensation, prayer A, my lord, for return the land, my lord. So far, my lord, in the writ petition, my lord, paragraph, my lord, 7, my lord, they have admitted that the municipality, my lord, started construction in the year 2021, my lord.
Yes.
So, my lord, 2021, my lord, construction is started. Today, my lord, 2025, my lord. Today, they are approaching before this honorable court, my lord. So far, my lord, the encroachment is concerned, my lord. There is no encroachment by the municipality, my lord. Total land, my lord, is 86, my lord, 86 decimal. There are lands available, my lord. Their claim is only 6.4, my lord. So we have not encroached, nothing has been done against their land, my lord.
Yes, madam, you have to say something.
No, your lordship. I just.
Miss Anna, you appear first.
I have just indicated before your lordship that since a civil suit is pending, I did not feel the need that why the writ petitioner is before the writ court.
Take down the petitioner in the comma, in the presented petition, comma, is aggrieved by the alleged encroachment of by the alleged encroachment by the respondent municipality upon the petitioner's land situated at LR number 26, right? 26. Mauza, Dalkola,
2712.
jail number 20, PS, Dakhola, district, Uttar Dinajpur, full stop. The counsel for the petitioner contends that his late father, during his lifetime, purchased 8.44 decimal of land at the above mentioned site by way of 2 registered sale deeds dated 1912-1995, full stop. Upon his father's demise, his father died intestate on 10/3/1993, the said property devolved upon his 4 children, including the petitioners, as legal heirs.
Full 6.
One of the legal heirs, namely late Kaushik Roy, during his lifetime, sold his undivided share of 2.1 decimal to the Dakhola municipality through a registered sale deed dated 1/2/2018, full stop. It is the petitioner's case that although the property remains undivided, the sale deed purportedly demarcated a boundary in respect of 2.1 decimal share, which the petitioners contend has been illegally encroached upon, full stop. It is further alleged that the petitioner, alleged by the petitioner, that the municipality is carrying on with unauthorized construction and has also encroached upon the petitioner's undivided land. Petitioner states, counsel for the petitioner states that he has already instituted a civil suit, being title suit number 164 of 2021, against the respondent municipality, which is currently pending adjudication before the civil court, full stop. The petitioner further states that the petitioner has also claimed his stake for compensation in the present writ petition in terms of the fact that the respondent municipality has encroached upon his land, their lands, full stop. In view of the said, the petitioner has filed the present writ petition, full stop. This court then take down the counsel for the respondent municipality states that the total land in LR 26 was 86 decimal. In LR plot number 26, so and so, is 86 decimal, full stop. He states that 6.4 decimal is still available with the petitioners, full stop. He has further pointed out that the petitioner were aware of the unauthorized construction or encroachment in the year 2021 as mentioned in the writ petition.
My lord, there is a correction, my lord.
My
lord, page 21, he said undivided. My father's property was demarcated.
These are statements, sir.
Yes, but I just want.
These are his submissions.
Sorry, my lord.
This habit of.
Or enforcement in the year 2021 as mentioned in the
Full stop. He states that the petitioner had chosen to remain silent and had not raised any grievance against the said construction for the last 4 years. He further states that the respondent municipality has constructed a crematorium on the plot which was sold by one of the legal heirs of late. What is your father's name?
My lord, late Fonibhushan Roy.
Late Panibhushan Roy. Full stop. Anything else? Any other submission?
My lord, there is no encroachment upon the land of the, my lord, the petitioners, my lord.
All right.
Since the
He has further stated that the present writ petition is devoid of merit and is not maintainable, since the petitioner has on one hand asked for handing over of the land which has been encroached upon by the respondent municipality, and on the other hand has asked for compensation in lieu of the taking over of the land of the petitioners. Full stop. This court has heard the submissions advanced by the counsel for the parties and has perused the materials on record. Full stop. In view of the discussions, this court is of the considered opinion that the issues raised in the present writ petition pertains essentially to disputed question of facts, including the extent of ownership, title, possession, and alleged encroachment over undivided property of the petitioners, which falls squarely within the domain of civil dispute, which are in nature of civil dispute and falls within the domain of civil court. Full stop. The petitioners have already availed such remedy by instituting title suit.
It's a partition suit.
Partition suit number 164 of 2021, which is currently pending adjudication before the civil court. Since the property is an undivided property, the allegation of the petitioners that there has been encroachment can only be decided by the civil court, for which the petitioner has already filed appropriate proceedings and the same are pending adjudication before the civil court. Full stop. The case of the petitioners that there has been encroachment in this court further finds that mere involvement of a statutory authority, mere involvement of a statutory authority like the respondent municipality does not, in the facts and circumstances of the case, render the dispute amenable to the writ jurisdiction under Article 226 of the Constitution of India. Full stop. The writ remedy cannot be invoked to adjudicate private civil disputes involving the issue of partition or possession of immovable property, especially where an efficacious alternate remedy has already been invoked by the petitioners before the competent civil court. Full stop. Accordingly, the present writ petition is dismissed. Is dismissed.
My lord, I am led by Ms. Sonal Sinha, my lord, for the state, my lord.
My lord, there is a writ petition pending, my lord, which I mentioned before your lordship with regard to the self-same plot of land, my lord, filed by another petitioner, my lord. That if that petition can also be
another petitioner, how
Yes.
can you file two petitions?
My lord, another petitioner means, my lord, Different plot.
How have you filed two petitions? First of all, tell me.
Another petitioner, my lord, not three, not they.
Not these three petitioners.
Not these three petitioners.
Who's the other petitioner? The person who has sold the land.
No, my lord.
There are
Another,
four sons.
no, my lord.
Three of you are here.
This plot of land, this municipality has taken away the land of this petitioner,
Yes.
as well as another person who has also approached your lordships, my lord. He had not filed any civil suit, my lord. He claims his land has also been taken away by the municipality, my lord. So,
See
my lord,
that whenever it has to come.
that's
Nothing to do with your case, sir. Are you the lawyer in that also?
yes, my lord.
Very good. Let it come. We'll see it. Let it come and we'll see it.
I'm
It's
grateful.
not listed here today.
Not listed, my lord.
All right. We'll see.
I'm grateful, my lord.
29 will I appear for the private respondents. Will at 29 and item number 40 can be taken up together. Will at two separate read applications in respect of same issue. Will at whatever I have understood, Millard.
Same lawyer?
Same lawyer, Millard.
29 and 40.
40.
Today there's nobody.
Millard, point number one, their contention is that we have raised unauthorized construction. Point number two, in another read application, we have destructed the underground drainage system and Millard sewerage system. These are the two allegations. Now, Millard.
The two allegations, two writ petitions.
Separate. Common prayer, demolition. Now, Millard, promoter has not been made a party.
One is demolition above the ground, one is demolition below the ground. So that's why two writ.
No, Millard, prayers are same, identical. Promoter.
All right, we'll have it. Take down the.
I'm for the statement.
None for the petitioner. In the interest of justice, adverse orders are deferred. Let this matter be listed along with writ petition number.
Millard, item number 40. 40 Millard.
Give the writ petition number.
2284 of 2025.
Along with writ petition number so and so. Tuesday. Wednesday. Keep it on Wednesday.
আছে কি
I'm for the Kolkata Municipal.
None for the petitioner. In the interest of justice, adverse orders are deferred. Let this matter be listed.
Tuesday.
এটা একটু নিন স্লিপটা নিয়ে নিন
ইনস্ট্রাকশনটা নিয়ে আসুন
ইনস্ট্রাকশনটা দিতে ফাইল করে
In this matter, I am appearing on behalf of the added respondent number 6. I will file
Your Lordship, I am for the petitioner. Your Lordship, the senior counsel for this matter is unavailable in the city. He's out of this city. So I'm praying for not this week.
Take down proxy counsel so and so appears and states that the main arguing counsel is in some personal difficulty. Let this matter be listed Wednesday. Nothing survives in the present writ petition. It's a tender matter, tender allotted. Payment has been made. Everything is over. Who you appear for whom?
Partial payment.
already received.
Tender allotted, work done, payment partially received.
They filed the objection.
What is left? Academic discussion.
Since they have
In this matter, I am for the petitioner. One difficulty is there, my lord. 4 documents, annexed 4 to 7 in local language. Well, I think those are required to be translated.
No, sir. This court doesn't get anything translated.
Not required.
Not required.
Well, so far, your lordship.
You can read it, I can understand it.
All right.
Yes.
Well, this writ application is against the inaction, against the Kolkata Municipal Corporation.
Yes.
For taking steps for demolition of the unauthorized construction.
Yes.
Well, the petitioner before lordship, that the absolute owner of a premises being number 33, Bhavani Datta Lane, Kolkata 12.
Yes.
Well, all of a sudden in the year 2023, the private respondent virtually raided my house, and at gunpoint, he compelled my client to put signature on a sale, well, agreement for sale,
Very
which is annexed P1. Your lordship kindly.
Very good. Yes.
My lord, your lordship will find from that agreement the total consideration money was agreed upon.
No, this is not P1, is sir property tax return.
My lord, sorry. Yes, my lord, to show my ownership. Sorry, my lord. Kindly page 29, P1.
P2.
My lord,
agreement for sale.
My lord, the corporate municipal taxes. P2, page 31. My lord, this agreement was executed by the petitioner before lordship, and it was agreed upon the property will be sold out at a price and a consideration money of 1 crore.
Sir, why are we?
I know, my lord. My lord, what happened thereafter? That was not executed, nothing of the sort.
Very good.
And that was not acted upon. No
Very
payment.
nice.
Well, thereafter, what happened? Your lordship, next annexure. After few days, they once again came forward. Oh, no, we are not willing to purchase the property. So it is better, let us develop the property. And accordingly, development agreement was produced before them, and they were compelled to put signature. No power of attorney, nothing was given to them to make any construction. Taking advantage of that, well, I do not know how they have procured sanction plan from the Kolkata Municipal Authority. And your lordship, series of my lord, the representation was made. And last representation, your lordship kindly come to page P8. P8.
Admittedly, there
Page
is
63. Page 63. This is the comprehensive the representation made before the Director General of Building and Executive Engineer. And everything in details were representation was made and everything was disclosed with a fervent request to take stern action against the private response number 7 and 8 and to demolish the unauthorized construction. In response to that, no action was taken by the municipal authority, and as a result whereof your lordship kindly page annexure P9, page 66, the photographs. A G-flap 6-story building is almost on the verge of completion. Without our knowledge, consent, nothing.
And I have the
Page 66.
report with me, my lord. Every steps have been taken. Report says so.
No action has
Even
yet
though
been
there
taken.
is a private dispute between the parties, but still, so far as the unauthorized construction is concerned, we have taken. They have filed the writ petition in January 2025.
So far, sale agreement.
আপনি রিপোর্টটা পড়ুন একবার আপনি বোধহয় জানেন আমাদেরই রিপোর্ট প্রাইভেট রেসপন্ডেন্ট এটা কর্পোরেশনের রিপোর্ট অন্য কারো রিপোর্ট নয় ভাঙা হয়েছে 408 এর নোটিশও দেওয়া হয়েছিল নোটিশ দেওয়ার পরে ভাঙা হয়েছে Demolition has been executed.
All of the building you kindly have a look at the photographs.
My lord, I am appearing for the private respondent 7 and 8. My lord, I am a little handicapped today. My clerk has missed my brief, but I remember the facts. I'll just state. There was a initially lordship, and it is also apparent from the writ petition.
Just a minute. What is there? The actions have been taken, demolition order has been passed. What do you want?
The building is still there in existence, G plus
We
6.
want the plan to be cancelled.
Your lordship, kindly direct me.
That is a private dispute
My,
between the parties.
no,
I
not
cannot-
at all, not at all.
My lord, what
My lord,
happened-
your lordship, direct my licensed client to cause an inquiry
Yes.
within a week.
What has happened was,
Your lordship,
lordship,
direct
even
I will-
from their pleading, there was initially an agreement for development. Initially, we had stated that we would be buying out the entire property. Thereafter, there was an agreement for development in which they have signed, which is I perhaps.
These are all civil disputes, private in nature. Why are you using my court for this?
No, I'm not using.
What is tell me what is there? You have a sanction plan?
Yes, the sanction plan is there. The corporation has also lordship filed a report.
Let
to
us
that
see,
extent.
let us see, let us see.
Creation has been demolished. Upon instructions I submit, and I think they have also taken steps. Notices have been issued.
Building is.
Lordship, they
Sir, please.
Sorry.
You're a senior counsel. What
Sorry,
kind of
sorry.
argument is this? You will not allow anybody to speak.
Sorry, sir. Sorry,
My lord, on instructions I submit that there was terms of settlement, which not terms of settlement, the development agreement. It records what is the consideration that needs to be paid to them. Now, perhaps, and that is my feeling, lordship, there may have been some demands here and there, and that is the only reason this writ petition has been filed.
Yes, now tell me.
Well, so far, our grievances,
Yes.
so far, agreement for sale, development agreement, we are not concerned with that.
Yes.
Let us forget about. We are concerned with the unauthorized construction. And according to us, the building is still intact. Nothing was done to demolish any.
Thing is intact because it has been constructed. Mr. Banerjee, you file a report.
Right. Again, I will file it.
Yes, file a report and whatever deviations are, because here you have not mentioned anything. You have not even mentioned that the building
I
has
will
been.
file the report extensively by showing.
In
how
this
much
report, it
demolition
is
was
not
there.
even stated
My lord, how much
that the
demolition-
building is constructed in accordance with the building plan.
My lord, I will tell them. I
You
will
have
tell
to
the-
mention that the building is constructed in accordance with the building plan. Then there's a deviation in the building. As far as the
what extent?
deviation is concerned, notice has been issued. You have taken action. Please file a report which indicates everything.
Let it be 4 weeks be given to me. I will give.
Take down
I'm seeking my lord's indulgence.
yes.
I'm ready.
The petitioner, comma, in the present writ petition is the petitioner, comma, in the present writ petition is aggrieved by the inaction of the respondent authority in not taking any steps against the alleged illegal and unauthorized construction being carried out at premises number 33 Bhavani Datta Lane, Calcutta, comma, allegedly by at the instance of respondent number 7 and 8.
Is it engineer?
Full stop. The petitioner states that they are co-owners of the said premises. Full stop. It is alleged that the respondent number 7 and 8 by exerting coercion and undue influence, comma, compelled the petitioner to execute an agreement to sell and a development agreement and subsequently a development agreement, full stop. Pursuant to the said first agreements, comma, the petitioner, the private respondent commenced the construction, commenced the unauthorized construction as alleged by the petitioner in the form of a multi-storied building at the premises in question without obtaining any sanctioned building plan from the competent authority. Petitioner states that he had made several representations before the municipal authority, but the same has gone unheard. Full stop. Learned counsel for the respondent municipality states, Mr. Banerjee states that the construction has been carried out in terms of a valid sanction plan. Full stop. Though there were deviations in the construction, there were deviations from the sanction plan. at the time of the raising of the construction, and that the municipal authorities had issued a work stop notice on 19/3/2024 under section 401 of the KMC Act 1980, full stop. Subsequently, an FIR had also been lodged against the alleged persons responsible for raising the unauthorized construction with the local police station on 21/3/2024, full stop. He further submits that proceedings have been initiated under section 408 of the Calcutta Municipal Corporation Act 1980, and an order of demolition has been passed, full stop. He further states that in terms of the demolition order, the respondent authority had taken action and have partially demolished the property, full stop. Further demolition action was also carried out on few more occasions on 18/12/2024 and 19/12/2024, as well as late as 18/3/2025, full stop. He seeks and is granted further 2 weeks time to file his report by way of an affidavit indicating the current.
Some more time may be given.
3 weeks? 4 weeks? 4 weeks, indicating the current status of the property and the action that has been taken by the action taken report by way of an affidavit shall be filed by the respondent corporation within a period of 4 weeks. Exception to the same, if any, within 1 week, full stop. Learned counsel for the private respondent seeks and is granted. You want to file?
Only if it is contrary to.
If you want to file, you tell me.
My lord, may give me that liberty, my lord. May kindly.
Only if you seek the liberty that learned counsel for the private respondent seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. List after 6 weeks, 8 weeks.
My lord, I'm so grateful.
8 weeks.
With your lordship, kindly.
Affidavit of service is taken on record.
8 weeks মানে কত হচ্ছে?
ये तमाल वो जो action taken report by way of an affidavit, exception to the same, if any, within 2 weeks. 2 weeks kar do, because we are giving him 2 weeks. Within 2 weeks.
একটা আছে 6
Develop life.
8
So far I am concerned, my lord, I am appearing for the private respondent. Unfortunately, petitioner has not obliged my client by serving a copy of the applications.
He is not here also.
So at least there's a direction so that I can read and know what is going on.
Somebody is here, sir. Who do I pass a direction on? Somebody has to be here. None for the petitioner. In the interest of justice, adverse orders are deferred. List on Wednesday.
So may I leave, my lord?
Wednesday.
No fruitful day.
Well, I appear for the respondents.
Same order. Wednesday? When do you want? Tuesday?
Tuesday or Wednesday, whatever.
Whenever you want, Mr. Ghosh. Up to you.
Lady, because 2-3 matters we are going.
Tuesday. 2-3 matters on Tuesday you have kept it. So let's put it on Wednesday.
Wednesday.
When do you want? Up to you.
Wednesday.
The rest of the matters tomorrow now. 30? All right.
Seek your lordship, my lord.
I'll call out 35 also. Call out 35.
30, well, 36 is my.
Wait, sir. 35.
For the respondent numbers 1, 2, 3.
Petitioner?
Yes.
Yes.
Your Lordship, I'm led by Mr. Shishanu Bandyopadhyay. He's on his legs, Your Lordship. I'm praying for a not.
Take down proxy counsel so and so appears and states that the main arguing counsel is busy in another court. She seeks a short adjournment. Let this matter be listed on
Any day as per Your Lordship's convenience.
Mr. Banerjee. When do you want?
Tuesday, Wednesday, any day.
Wednesday.
Advertisement tax. আপনারা নিতে পারেন না চার্জ করে দেন।
Next is also Havra, I think.
Havra, ma'am.
Havra. 36.
36. This is a glaring example, my lord, where a sanction plan was obtained, my lord, for G+4, my lord. When I filed this repeat application, my lord,
yes,
G+2 was constructed. Now, my lord, after filing of the read application, my lord, Speed has filed up now and he has constructed G+7, my lord.
That's good for you.
My lord,
he will suffer more.
My lord, only thing is, my lord, they have encroached my portion, my lord. The public sewage system has been, my lord, collapsed, my lord. My walls of the western part has been cracked, my lord. And my lord, the safety tank, my lord, which I have, my lord, is cracked, my lord. Well, these are amendments, my lord, which I have made, my lord. And this is, my lord, the sanction plan which I have obtained, my lord, through
For
RTI.
all those, you should file a civil suit for unauthorized construction. This court is fine.
My lord, beseech, my lord, let a report be filed, my lord, because I am before your lordship, my lord. And the plan says, my lord, he has been obtained favor to G+4, my lord.
I will file a report, my lord, let time be given.
In the meantime, my lord,
Petitioner has preferred the present writ petition being aggrieved by the inaction on part of the respondent respondent corporation.
Thank you.
In not taking any action any action
my lord,
against the alleged illegal and unauthorized construction being carried out at premises number 76 Upendranath Mitra Lane, PS Kolabari, PO Salkia, District Havra.
Inspection, my lord.
Allegedly by the respondent number, private
10,
respondent number,
respondent number 10, my lord.
Private respondent number 10. Full stop. You stay in the property?
My lord, I stay in the, my lord. This is the sanction plan, my lord, which I have obtained from RTI, my lord. Through RTI, I have obtained.
It is the case of the petitioner that he is the absolute owner of premises number 77.
Yes, my lord.
77, Upendra something something, and stays with his family at the site. Full stop. The respondent number 10 obtained a building sanction plan
here is a
for
sanction plan.
G+4 floors. And full stop. G+4 floors. Full stop. In contravention of the said building plan, the respondent number 10 has constructed G+7 floor without any valid building plan, without any valid sanction plan.
And there was encroachment in my property also.
Learned counsel for the petitioner further states that the private respondent has encroached upon petitioner's land. Full stop. He further states that due to the unauthorized construction, the property of the petitioner have been damaged.
And my lord, the drain, my lord, the municipal drain, my lord, has been totally been collapsed, my lord. It has been, sewage system has totally been
damaged, as well as his property has been damaged, as well as the municipal drain has also been damaged due to the alleged unauthorized construction raised by the private respondent number 10. Full stop. You can decide his representation.
Decide the representation, my lord. That also I can do.
Your lordship, let them file a report, because I tell you, lordship, my lord, I cannot file. I am mighty, my lord. Your lordship, kindly appreciate senior citizen, my lord. I have made your lordship.
Some time may be given for inspection.
My lord, I have
inspection and hearing that. I will come complete with after completing.
My lord, 4 representations are there, my lord. I am senior citizen, my lord. I have, when I filed this writ application, my lord, it was G+2, my lord. Your lordship, kindly appreciate.
I appreciate, sir. That's why I am passing an order.
My lord.
Learned counsel for the respondent municipality, Mr. Sandeepan Banerjee, seeks and is granted 4 weeks time.
6 weeks, sir. Because the inspection will have to be done. I think it will be better for him also.
Inspection.
6 weeks time to file his report after conducting an inspection to ascertain the nature of unauthorized construction.
Right.
Full stop. At the time of carrying out the inspection, the notices should be served
Right.
upon the
Joint
petitioner
inspection.
as well as the private respondents to assist the corporation at the time of the inspection.
পুলিশ লাগবে?
পুলিশের পার্টি আছে রেসপন্ড নাম্বার 9
পুলিশ কি লাগবে ওখানে ইন্সপেকশনে?
বলে না
Exception to the report shall be, if any, shall be filed within 1 week, 2 weeks. 2 weeks thereafter, list after 8 weeks.
Only I beseech your lordship, let up a stop work be your lordship kindly protects me,
When I will initiate the proceedings, automatically stop work will be done.
Your lordship kindly record his submission,
Yes, automatically.
Your lordship.
It is part of it, sir. Any unauthorized construction, you should be happy. Let him put few more thousands, few more lakhs. You should pray. Let him. How can they regularize if it's not? Regularization is not there in the Havara Municipal Corporation Act. Where is the provision for regulation? Mr. Chakra, what are you saying?
He is thinking of that 43 item, whether it can be adjourned or not.
43.
43.
So that yes, tomorrow your lordship will be taking a original statement that I will not be clear. 42 and 40.
But two টা চলে এলো।
What? Which matters? No matters anymore. Done.
So I'm just seeking.
কাউকে পাঠাবে শুক্রবার করে নেবে আবার কি আছে?
Right. Whatever.
মাইলে।
Orders, madam.
Back.
আরে আমি তো দিয়ে দেবো, আমি করে দেবো, আমার দায়িত্ব।
Gratefully, lordship.
স্টপ ওয়ার্ক নোটিশ আমি দেবো।
The rest of the matters.
জজ সাহেব
ঠিক আছে। Friday.
বিল্ডিং